17/10/2025. That was the order which was passed in the motion stage, my lord. The instructions are awaited. Nabojyoti Gas Agency, my lord. There's an interim operating, my lord, in favor of the petitioners. We are awaiting instructions as of now, my lord. The matter can be adjourned for a short while, my lord. On January, my lord, the matter, we can file a rejoinder then. It was regarding debiting of an amount, my lord. It was pertaining to debiting of an account from the PAD account of the petitioner. The detailed order passed, my lord. That is all.
I gave you time, pretty long time.
My lord.
So we'll make that
My lord, we'll require
interim
short.
order until further orders.
In fact, what had happened, my lord, was
You have, in that case, demanded something without arriving at a conclusion,
my lord,
to that effect, that this person concerned, there was a particular finding is required to invoke the second option.
targeted delivery schedule, which we had said that the petitioner had failed, but there was nothing. Your lordship is right, my lord. There are 3 years had to be shown in the impugned order.
So we allow him, you have given him an opportunity, you have not filed it. So
Your lordship will grant us one opportunity, my lord. Then your lordship will.
We'll see when the matter is taken up, not now.
In the matter is taken up. My lord, my lordship.
May I please the lordship, my lord, I pray for listing of a motion matter, my lord, on Friday, my lord. Obliged, my lord.
May I please your lordship? Lordship, I'm praying for to bring on record affidavit and additional affidavit in item number 65 and 66.
May I please lordship? I pray for bring on record one affidavit in reply filed by the petitioner on item number 26, lordship. Of list.
May it please your lordship. Lordship, I beg to mention a fresh writ petition for urgent listing this Friday, lordship.
This is also for listing, my lord, on Monday.
What matter?
For admission, this matter relates to settlement of guardian.
What is the urgency before vacation? Monday.
Yes, my lord, Monday.
Your lordship, I beg to mention an IA for withdrawal, lordship, on Friday.
For motion item 1.
This contract file will put into of the order is the losses order taken 22 11/24.
Get hold of Mr. Esbora. We'll take it up. Ask Mr. Esbora to appeal.
My lord.
We'll take up item 1, 2, and 3 once Mr. Esbora appears. এখনো এটা নোট এটা করে দিয়কচোন asking Mr. Esbora to appear ticker এটা উল্লেখ
I appear for the writ petition, my lord. I appear for the writ petition, my lord. This is concerning the tender process with respect to Kachar paper mills, my lord. Your lordship has also taken up some other matters, my lord, which is also I see are in the list, my lord. My lord, the writ petitioner before your lordship, I will be candid with your lordship, my lord, had not participated in the tender process. My lord, the writ petition is based on the fact that why the writ petitioner did not or could not participate in the tender process.
In view of that certificate?
No, my lord. There were 2 points taken in our writ, my lord. The first is inadequate publication of the tender, my lord. This is a high value tender, my lord, which was published only in the respondent number 2's portal, the MSTC portal, my lord, which was the agency taken up for publishing the tender. My lord, apart from the portal, this particular tender has not either the abridged form or the entire tender published in any other government portals, any other newspapers, whether circulated in Assam or outside the state of Assam. My lord.
Call Mr. D. Deka, who is appearing for the other side.
My lord, I'll
Ask him. There's a standing council of these people. ASIDC. This is done by the ASIDC, no?
My lord, and the second point, apart from the
AIDC.
yes, ma'am. Yes, the terms.
In the meantime, they have already, why haven't you made those technical bidders, technically competent 4 bidders a party to this present petition?
My lord, I am not aware of the entirety
If
of.
you are not aware, you are sleeping all the while, then you can very well come before this court.
My lord, may I? We had filed a writ petition. This was adjourned on our ground, my lord. We had filed a writ petition prior to your lordship's last order, where your lordship directed the other persons to be given a notice in view of previous orders by this honorable court, my lord. Now we see, my lord, what we have been able to ascertain from the other writ petition, that an application has been made to implead the other parties, my lord, subject to what, because I am not a party in their writ petition, my lord. This is only hearsay, my lord, that I am aware that the matters are listed today in the supplementary list. My lord, my writ petition, if your lordship sees the date of filing, was prior. We sought for an adjournment on that day, my lord, on our ground, and your lordship had adjourned it. Now, my lord, when your lordship kept the other matters on 10th, in view of the development in that matter with regards to, but that's the edifice matter, if your lordship remembers.
This is another matter filed with your Kachar paper mill problem. This is on the count of non-publication of wide publication and all. There are other 2 matters listed today.
Yes, Lordship.
Item number,
62, 63, 64 in supplementary list.
we take up this matter along with those at this point of time.
Yes, Lord.
Because if I pass an order, then this has to be tagged with those.
Yes, Lordship.
So it will may be difficult. Because here he questions on not making a wide publication.
Yes, Lordship.
But anyway, there were already 20 bidders who participated, of which 3 were found to be technically
Technically qualified.
competent. And this court made 1 more
Yes, Lord.
technically competent, for which you have another petition filed by Mr. Das,
Yes, Lordship.
saying that this certificate is absolutely not necessary. This is what is their submission.
Yes, Lord.
And that is what the matter is being taken up. Anyways, we take up together.
In our writ petition also, my lord, the second view of challenge, my lord, after we got to know about the tender terms, my lord, we have also, according to our understanding, my lord, that the tender terms were also tailor-made. That's our second challenge, my lord. That's 2 challenges.
We'll take the other matter,
Yes.
together, all these matters together.
Yes, Lordship.
You have got a copy of this with.
Yes, Lordship.
But this formal notice has not been issued in this matter as far as,
But we
I
have got
know
a-
that.
yes.
we have got a
The
copy.
moment I
Lord.
issue a notice here, it will have an impact. Yes,
Lordship.
you are appearing in this matter?
Yes, on behalf of AIDC Lordship.
Yes, tell me.
On the last occasion, Lordship was pleased to give a direction that some new parties may be implemented.
To the petition.
Yes. So if they are implementing a fine,
He's
otherwise we
not
can,
here. This is not that petition. The petition, those petitions are at item number 62 and 63 and.
Lordship. In this case, we are ready for hearing, Lordship. Any day, Lordship may be pleased to fix. We have filed all
No,
the.
first I have to issue notice in this matter. This matter, I have put it with the other 2 matters. There is an interim order passed in the 1 matter.
Yes, Lordship.
Now, only a question, Mr.
Mm.
Sekia, the question is like this. Out of 20 tenderers, bidders, 3 were technically competent as per what
Lordship.
was your decision. This court held your decision of rejecting the petitioner in edifice to be proper
Lordship.
by way of an interim order.
Right.
But at the same time, say, allow him to participate. And this is a different type of tender, unlike where you give both the financial and technical bits together. Here you have the, once you are technically qualified, you can participate in the auction. Resultantly, there are other bidders also who had this certificate or could have submitted this certificate.
On time.
And by an order passed by this court, in my opinion,
Yes, yes, I'll make my submission on that, Lordship.
there's a violation of Article 14. So the only way I could see for the mistake committed by the court, because a mistake committed by the court should not be in a such that it prejudices the other party. There's a question of, I think there may be a requirement of having a fresh auction, nothing more than that. Taking into account, therefore, I ask all the other parties also, if they have any claim, it's a different thing. If they don't have a claim, is another aspect. So that is what the scope of the writ will be, subject to what you submit. We will have this along with those two matters together.
The only thing is that, Lordship, we have proceeded with the auction in terms of the court's order.
That is.
Yes, that is number one. Now, at the worst case scenario, if Lordship directs, we have no difficulty. Suppose the person who bidded the highest, I think the person who has defaulted, he is the highest bidder. If we ignore his bid and the next bidder who gave a quote in the auction, that can be one way, because otherwise AITC.
Again, a problem, Mr. Saika, what problem it is? He may very well say that this person, because if you see, I have seen that it was produced before me in a seal cover. These two bidders, there were four. Two bidders did not quote much. And from 30 lakhs onwards, it spiraled
Yes.
between these two.
So one is valid tenderer and one is not.
valid.
So whoever is the valid, whatever is highest quote.
But the problem is, he may very well say that this person was totally not eligible. So under such circumstances, my quote was 30 and it spiraled to 87 because of that.
Otherwise, what will happen now? If Lordship, whatever, I do not know, whatever is playing in Lordship's mind, if a fresh auction has to be taken place, it should be taken between amongst all the bidders, I mean, the three or somebody
No,
else.
whoever has that OSC certificate or whether
That means three. three.
No, they also have. Number 4 also has.
Number
Other-
4 has have, but he did not have, he did not submitted it. He
So
did not
therefore,
uploaded
this
it.
court permitted it. So unless I dismiss because I cannot touch that person, because the court permitted, I will be sitting on appeal against that order. Problem is there. So therefore, the entire technical evaluation which was done, the touchstone of yours that you, without that OSS certificate, you are not going to permit, which he did not submit. The reason is, and the court permitted it. I can't sit over that.
Yes, that is
Problem
another
that
issue.
I can't sit, but because
Because
of
there,
the-
nobody has come for vacating of that order or non-implementing of.
vacate that order. But you can't vacate that order because that is the final, almost a final.
There's a final,
judgment
this is
passed.
what I have said. It is just like deciding the matter on that date.
On the first date itself.
On the first
And more
date.
particularly, I think at that point of time, the learned coordinate bench did not realize what type of bid it was. It was a bid, it was normally thought that, okay, the financial bid will take care of it later on. It is normal which we have, a technical bid and a financial bid quoted together.
If it is from the stage of auction, we have no difficulty. But if we have to redo the whole tender process, then we have some reservations.
No, those, only thing is those persons concerned who have that certificate as on that day but did not submit, they should be permitted because otherwise,
That was the view of the honorable court also on that day.
but you only allowed him, the petitioner. But others have been not allowed. So maybe other persons may not have on that day or may have it late. These are other aspects of the matter. Whereas Mr. Das repetition is on a different scope. He said this type of certificate does not exist. That is his case. There is another certificate named as OMYSMS or something,
OHMSS,
which he had got.
OHSMS.
That he also has that contention. So let
Now,
us.
some petitioners are now coming that particular certificate is not required, or it is,
Now, that certificate does not actually exist. That
if
is
it
what-
is does not exist, then how can others have submitted?
Only 4 has supplied.
Then
So
that means it exists.
that-
It
May I
exists.
not just add with the.
We will do one thing, we'll have those matters together at 2 o'clock then. All these matters together because of the fact that those matters are there because that counsel from edifice is not here. Counsel from edifice is not here. So without that, I can't go ahead with that matter. So let us have it after some.
So other cases, these are for motion, lordship, or for
No,
orders?
no, those are for admission. So these are 62, 63.
What I suggest that all the cases, whoever has whatever pleadings they want to file, let them file, and on Friday, the matter may be taken up for final disposal. Or maybe
Friday-
on
Friday
reopening,
is too
or
early, today is
reopening.
Wednesday.
Today is Wednesday, that is day after tomorrow.
So Friday, how can they? if
Then-
you-
then
Are you
lordship-
not going to submit a reply to them, what they say?
Then all the pleadings may be exchanged, and lordship may be pleased to fix the
One
matters
day.
in the first week of December, January.
Let's hear them also.
Yes, lordship. At 2 o'clock.
At 2 o'clock. Yes, Mr. Esbora. Where is it? I saw him somewhere.
Deeply obliged.
Mr. Esbora, you were the counsel, therefore I'm asking you. I normally don't issue first day a notice because it becomes very difficult to drop later on. So I'll ask you to inquire why the order has it been complied with, and if not, why?
My lord, may I, my lord? In a similar case, I have filed an affidavit, my lord. The money has been to the Department of Housing and Urban Affairs. Later had been sent money for sanctioning of.
Come with that explanation also. You don't need to file an affidavit
Not-
now. Because I'm not issuing notice.
Not-
I'm only asking you this thing to get an instruction as to whether it
Furnish
has
me the
been-
copy of the.
Don't worry, that will be done. Don't worry. প্রত্যেকটাতে একে order যায় বিপদে। This is an application file alleging willful and deliberate violation to the order passed by this court dated 22/11/2024, passed in WPC number 5882/2024, whereby there was a direction passed by this court to verify as to the entitlement of the petitioner. And if it is found that the petitioner is entitled to any amount, the payment be disbursed within a period of 3 months from the date of service of a certified copy of the order. The materials on record reveal that on 6/12/2024, the order dated so-and-so, 22/11/2024, was served upon the Commissioner, Guwahati Municipal Corporation. It is the allegation made in the instant petition that the said order passed by this court dated 22/11/2024 in so-and-so have not yet been complied with. So, taking into account the said allegation, this court therefore requested Mr. Esbora, who is the standing counsel of the GMC, as well as who appeared on behalf of the GMC in those proceedings, to obtain instructions as to whether the order dated 22/11/2024, passed in WPC number so-and-so, have been duly complied with or not. And if not, the reasons therefore. First of this a copy of the present contempt application be served upon Mr. Esbora so that he is in a position to obtain necessary instructions. First, the registry shall also show the name of Mr. Esbora as the standing counsel of the GMC. First, list this matter again on 19th of January 2026 for an update in the motion column. In the meantime, try to comply all the 3.
Lords.
Same. তিনটা বেলেগ বেলেগ হ'ব, হা?
non-payment of hires bill merit of this.
What?
Non-payment of bill merit of the vehicles.
Non-payment will go to 9th of March, filing affidavit by 2nd of March.
So this matter relates to cancellation of fair-based license lordship. Similar matter, your lordship, your second,
Same order. When did I fix it?
2nd of February. Where are these all?
Two type order silo. buddy.
7 is also similar. Lord. 7 is also similar.
7?
Item 7 is also similar. No, 7. Obliged. Lord.
Miss Udas was appearing in those matters.
Yes,
na?
Lord. There are 3 more matters.
In this case, you will appear.
Obliged.
What is this?
May I please, your lordship.
Ah,
Lordship, the grievances of the petitioner is this, lordship. Sorry, the grievance of the petitioner is this, lord, that in the year 1990, he had taken electricity connection of 1 kilowatt. He was using it till 2022, and your lordship, it was upgraded to 2 kilowatt electricity meter. But after 3 days of installation of that meter, lordship, that meter did not function. It stopped working. So lordship, he approached the responding authorities to either replace it or your lordship, you repair that meter. But lordship, that was never done. And lordship, since then till today, lordship, all the electricity bills are being given in an assumption manner. Lordship, under assumption, without any proper billing, lordship, these bills are being taken. So lordship, continuously, I was approaching the responding authorities to either replace or change the meter. Lordship, on 10/9/2025, lordship, you will find the page number 23. Lordship, a notice was issued to me, and lordship, arbitrarily, lordship, they are imposing me, they are forcing me to install a 10 kilowatt meter, lordship. And lordship, if I don't do it, lordship, they are threatening me they will discontinue, they will disconnect my connection. Lordship, I'm suffering, lordship. And lordship, lordship will find by the last lecture.
no, your connected would be the connected load.
Lordship.
What will be the, they cannot say that you have a 10 or 20 kilowatt meter. They don't. Meter must be a 3-phase meter. They must be asking you.
No, lordship, this is my case, lordship. They are forcing me to install a 10 kilowatt meter.
There cannot be a 10 kilowatt meter.
Lordship,
The question is 10 kilowatt of contracted load
Yes.
is the question they are asking you.
Connected load, my lord. The
So,
enhancement of.
rightly so. How can this court look into this? Go to the
Page-
consumer redressal
Page
dispute.
24 is the reason, my lord. Page 24 is the assessment carried out, where we found, my lords, against a sanction load of 2 kilowatt, he's been using power to the tune of 10
Tube light 6 numbers, fan 10 numbers, TV not there, CFL, AC. You have 3 ACs.
Lordship, this is wrong, lordship. They have conducted this entire exercise in my absence. And lordship, I'm challenging this thing, lordship. Neither I'm using 3 ACs, lordship. That this is my case, lordship. I was using 1 kilowatt. Then again, I upgraded it to 2 kilowatt, lordship. And lordship, I don't use this. And still, lordship will kindly see.
How big is your house?
It's a 2-story building, my lords, and he's running a school from the ground floor.
Are you?
That I'm not aware, lordship. But
You cannot be unaware when you are coming before the court.
lordship, I will be fair, lordship. I don't know that whether it was running a school, but lordship, as per the instruction I have received, lordship, he's not using all this electronic apparatus.
Are you saying that you don't have an AC?
AC, though I have 1 AC that he has informed me.
Only one.
One AC.
If they find another 2, they will confiscate it. You give an undertaking.
Lordship, I have to take an instruction.
No, give an undertaking. That, okay, we'll pass that order, provided if they find anything to that effect, it belongs to you. They will take it. Okay?
That part I have to take instruction, lordship.
Then, don't come up with all these things. Go before the consumer, they have a
Yes,
redressal board.
CGRF, my lords.
Go there.
In
This
fact,
is not
my lords,
the forum for this. You'll get a much deterrent order from this court.
But your lordship, without meter, they are charging us, lordship. Last month also I paid 24,000.
Go there. Say all these things before them. They have a consumer, what that forum?
a consumer grievance redressal forum. my lord.
Go there. You have that. Why you are filing this
Lordship, they
petition?
are threatening me to discontinue, lordship.
Very good. Go there, they will ask you. They will discontinue, obviously. They will disconnect everything unless and until you correct your connected load. That is the mandate of clause 7.4.
Two, my lord.
Withdraw, go there. What is the full name here? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary, the learned counsel appears on behalf of the APDCL. Withdraw, dismiss.
Lordship withdrawn.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to approach the
Consumer
consumer
Grievance Redressal Forum, my lord.
forum as regards his grievances. He therefore submits that the petitioner would not like to pursue the present proceedings. Taking into account the above, the writ petition therefore stands closed. On withdrawal, the withdrawal of the instant writ petition shall, however, not prejudice or preclude the petitioner from approaching that full name to liquidity.
I'm obliged, Lordship.
I have to kindly pass over the matter for the.
Why?
The adjunct attorney is on Lex in court number one.
No, you argue.
Well, I'm not in the matter.
Huh?
I'm not in this matter.
Okay, none appears. We'll go for after 4 weeks.
Well, I can it's taken after some time.
We shall not be issued. Well, what is that order?
Well, 48.
Page 48.
What a lordship will see page 37, madam. There is an amendment made in
With
2020.
reference, I am to send here with a copy of the letter received from the Commissioner of Iman regarding non-compliance of VAT rules by a number of WEN. It is therefore requested if there is any outstanding VAT or any other government liabilities remaining unpaid by the online seller under your jurisdiction may not be renewed for the next term as per section 128. They noted that for renewal of license may be after 7 and 6 months. You are asking a NOC from the tax officer on what basis? You may not renew it, it's a different thing. But what is your basis to ask about the NOC?
There I will have
Unless
to
the
accept-
act says so.
But that is not the main grievance, my lord. My lord, the act was amended sometimes in 2015. Adding that, my lord, 6% additional VAT. That they are saying, my lord, it cannot be now made retrospective. But my lord, the act has been amended in 2015, my lord. Their question.
It has admitted, but the act was amended in the year 2015, but now they have issued the notice for registration in the year 2025. No, from 15.
Or
25
realizing,
Yes, my lord.
was it made retrospective?
No, my lord, they have, in respect of my wine shop, my lord, also, they have not made it clear, my lord. But in respect of other shop, my lord, they have already.
No, whether the particular provision
Yes.
was given retrospective of operation from 2015 or not.
No. No, my lord, from.
Where is the amendment?
My lord, can you see the amendment?
Page
my lord?
37.
37, my lord.
You to put this here. Put this here.
Section 2.
This is of 2015 itself.
Yes, my lord.
Then
Act amendment.
Now, my lord, they have issued the notice for registration under this provision, my lord, now in 2025, my lord.
where is that provision?
Page 37, 2, my lord, amendment to section 10.
Notwithstanding anything contained in this act, the retail on license user for portable so and so, except country players shall pay output tax on sale made by him at the rate of 6% without set off of the tax paid on purchase made by the bonded warehouse subject to the condition are purchased locally from the bonded warehouse of the state. Then, where is the question of registration?
Yes, my lord. Kindly come to page 35, my lord.
Huh?
Page 35. This is the notice issued in the month of July 25, my lord. You are hereby informed that as per provision of so and so, you are required to get registered under the act under notification number so and so. You are directed to apply for registration within 15 days from the date of this notice, providing all necessary documents and information. So now they are asking us to register under the provision, my lord.
So,
So we have been running our own shop, some of them from 1995.
no, I'm not concerned about that. You see, as per section 10(1)(a), earlier as per VAT, if I understand correctly,
Yes, madam.
it was at one point, the point was at the time when you are lifting it from the warehouse. This was the law. At that point of time, when you are lifting from the warehouse, you are to pay. Bonded warehouse. So the point of sale was at that point of time. And recovery, because in a tax, there are three aspects. One is the point of sale. The point of sale was considered there, and therefore the sale was, you had to deposit the tax at that point of time, and they are going to make, the bonded warehouse is going to make the payment. So you don't require a registration. Now, as per the 2015 amendment, you are also being made liable to pay another 6%.
Yes. In addition to that VAT, my lord.
That is immaterial. I am not on that. The moment you are liable to make that 6%, unless you are not registered, how can you pay? Tell me.
Yes, no, we cannot pay, my lord.
Tell you, unless you are registered.
Yes, my lord. No. That is why my lord, now they are giving us notice that we have to.
No. When the law has come, you have to register at that point of time. Have you seen the VAT Act? Who is liable to be registered? Who is liable to be registered? Any person who is liable to pay tax is liable to be registered. So in 2015, the law came in that manner.
Yes, my lord.
So at that point of time, you were liable to pay. It's a different thing. Whether they can claim this after such a long period by going for an escape turnover. It's another thing. You can only register from 2025. But as regards that, whether they can go for an escape turnover after 10 years or 15 years is another aspect. That is another provision of law for which you need to take care of another aspect. But otherwise, the registration directed upon you cannot be said to be wrong unless you challenge to the
No.
10(1)(a).
We are not on that, my lord. Basically, I am agree, my lord. We are not agree by this, my lord. Basically, I am agree by the subsequent notice issued by the excise authority that if there is any pending VAT, then they are not going to allow me to renewal for the next financial year. I am agree by that notice, my lord.
Which notification?
Page 48.
That is it.
Page 48, my lord.
Hmm.
With reference to the subject cited above, I am to send here with a copy of the letter as received from Commissioner of Taxes, Assam White, letter under reference above regarding non-compliance of VAT rules by a number of on-shop liquor license. It is therefore requested that if there is any outstanding VAT amount under government liabilities remaining unpaid by the on-shop licensees under your jurisdiction, then such license may not be renewed for the next term as per Rule 128 of 2016.
Rightly. What is wrong?
There's nothing wrong, my lord. Because, my lord, now, my lord, we have to register it. We'll register it. But in some cases, my lord, they are demanding the VAT amount from 2015, my lord.
Where is the demand?
In respect of our shop, they have not quantified the demand.
No, Mr. Counsel. Again, you have not looked into the VAT Act. If there is any amount to be paid, they have to put a demand notice. You see, you have a self-assessment. You may not have done the self-assessment. You see, there are three types of assessment. One is a self-assessment, one is a scrutiny assessment, and one is an audited assessment. Normally, you are required to make a self-assessment and submit like you do for the income tax. You may not have done it. This would result in an escape turnover. If it is escape turnover, they are to take action as per section 36. Then they are to take action. They have not taken action. So, As of now, where is your demand?
But in view of this, my lord, this notice, my lord, now they will deny my renewal, my lord. That is why I am before your lordship.
But where is the demand?
Though there is no demand on papers, but in view of this notice, my lord, Excel authority will not renew my license. That is why I am before your lordship, my lord.
Excise authority won't knew, obviously, if you have liable to pay, then you have to pay. How can I stay this?
There is no demand.
Very well.
There
You
is
should
no
be
demand.
happy.
In respect of, at least our wine shop, my lord, there is no demand. Because they have only issued the notice. Demand has not been given to us, my lord. But in view of this, because since registration is not there till date, my lord, and no, they will not allow us to renew, my lord.
So have you filed your application for renewal?
It has to be filed
When did you file?
in the, before 31st of December, my lord.
You have filed.
That is information, today I don't have.
Then how do I, where is your cause of action?
Because there is a clear instruction from the.
Ask the submission of renewal is February 15th.
That case? No notice. Let us dismiss it.
Kindly peruse
No, no.
section 120.
I think this is a good case for
Section 120,
dismissal.
my lord.
Today I have not got any chance to dismiss. Your case would be the first one. Yeah.
120, my lord.
No, no. What do I see about one? Hey, excise continue. Let me start the day with a dismissal of Mr. N.J. Katunia's matter.
6.
128.
129. 128 is a renewal, my lord, and 129 is the submission of annual renewal proposal.
Section or rule?
Rule, my lord. Provision is there, my lord. That we have to
All
submit
retail
before 15th
license
of
for the
December.
so and so and other returns granted under this rule shall be renewed annually by the demand on payment of the prescribed annual fee if there is nothing adverse against the and if no government dues remain as area. So rightly,
To 15th of February.
Huh?
15th of February is the last date of submission of.
so as of now, there is no demand.
As of now, no demand.
So if there is no demand, how can you be liable? Let them put the demand. If they are not putting the demand, how can you? So at that point of time, a cause of action will arise.
Because in similar cases, my lord will find a similar order here. That,
Where?
page 47,
Yeah.
in respect of some on-shop, my lord, demand has been made, retrospective demand has been made, my lord, and they preferred a repetition. And that repetition notice was issued, my lord, page 47.
So their notice is issued. We do one thing. We dismiss your petition and then say these matters to be again come before me. And we dismiss those also on Friday. Give us this. What do you want? No. As of now, nothing is there. Unless you challenge the provision of 1A. You have to
That-
challenge 1A.
That I understand, my lord, because we are not equipped by the, at present, we are not equipped by the 10A, my lord.
No, first and foremost, Mr. Counsel, you have to appreciate. As on 2015, the law had changed.
Yes.
On that day, all on-shop license holders are liable to make us additional 6% deposit of VAT. Meaning thereby, this would be at your end. And for that, you are required to file your returns. You don't file your returns. Now you have come all the while after 10 years. Then look here, I have not filed the returns. It's a different thing. I have not registered myself is also a different thing. But they have not demanded me, so I don't have arrears. This is your case.
Yes, yes.
So we dismiss it right away.
The only thing, my lord,
No. This is a case for
Also,
dismissal. What do you say, Mr. Gogoi? Case for dismissal.
Let him decide, my lord, he may withdraw also, my lord.
Huh?
My friend may withdraw.
because, my lord,
No. Today I have already allowed somebody to withdraw. So there has to be a first dismissal today. No dismissal. I've issued notice, all these things.
well, this is
The
notice.
day has
Notice.
notice?
Yes, my lord.
Notice is too far off. Whether I will be allowing you to withdraw the writ petition is that question, not a notice. This is a complete violation of the law. Chalo, let us dismiss it.
At this
Or-
place, notice me go, my lord.
No, no, no.
Because
Heard Mr. NJ Khatun. No, no, Mr. Not,
ground is subsequent, because my lord,
no, no, no.
excise authority are now trying to.
Absolutely, rightly so. They have done it. Dekho, enough.
Because my lord, they have never asked us.
And after this order, you mentioned the other two matters, Mr. Gugoi.
Fine.
So we'll dismiss those also on times. Okay, heard Mr. NJ Khatunia learn it because others may not withdraw, na? So with this, it is covered, he will submit.
Because in other cases, my lord, they have already made the demand.
Mr. Khatunia, are you not understanding what I am trying to say? As on the date on which 10(1)(a) was brought into the statute books,
Yes.
your liability has accrued on that date itself the moment you make a sale. The moment you are making a sale, and therefore you are also liable to file your returns. Once you file your returns, how do you file your returns unless you are registered? The non-registration of that is also a case of escape turnover, which they may take a plea now, which I'll give them the permission to do so. Chalo.
But they have never insisted us to register under the VAT, my lord.
You see,
They have
you
issued
see
the
that
notices.
the tax authorities were a bit, they were sleeping.
In the year
They woke up
two thousand
when
fifteen,
Mr. Gogoi took up the matters
in the year
seriously.
2000, amendment was made in the year 2015, and they have asked us to register in the year 2025 after 10 years.
Mr. Counsel, is it required to ask you to register?
They have
No,
allowed.
no, no, no. Tell me, is it that? Let us see the VAT Act. So, no. VAT Act. Hey, pale, most of it. After many days, I'm getting a tax matter. Good. Let me do it. Now, who is required to be registered? Let us see VAT. Registration will be section 7 or 8 somewhere. Taxing authorities. Incidence of tax. Subject to other provisions of the Act, every dealer. Tip, section 7.
Yes, my lord.
Subject to other provisions of this Act, every dealer who has been liable immediately before the appointed day to pay tax under the so-and-so shall with effect from the appointed day for the purpose be liable to pay tax. Subject to the other, every dealer does not apply and whose turnover or sales calculated from the commencement of any year after the appointed day exceeds the taxable turnover within such year shall with effect from the date of immediately following the day on which his turnover exceeds the year be liable to pay tax in accordance with the provisions of this Act. A dealer registered in the Central Sales Tax. So this is how your liability accrues under 7(2). Now let us see who is required to be registered for the purpose of levy of tax, certain sales, exemption, liable to levy of tax on sales. Every dealer who is liable to pay tax for any year under sales shall pay output tax on his taxable turnover for the year. Country spirit, fourth schedule, the officer in charge, and so and so, so and so. Registration, levy of taxes on purchase. Look it up, Nadi. People give these books and tell them where is the registration. Returns every registered dealer land for yeah. Yes. Finally come to section 21. No dealer shall, while being liable to pay tax, carry on business as a dealer unless he has been registered and possesses a certificate of registration. So therefore, as you are saying that you are not registered, we ask you to stop immediately your business. You cannot carry out on business as a dealer unless he is registered. So we stop your registration work. Chalo. Heard Mr. N.J. Khatonia, the learned counsel appearing on behalf of the petitioner. Mr. B. Gogoi, the learned additional.
In that case, give me some time so that I can,
No, enough of time.
take it up on tomorrow.
No. 25,000 cost tomorrow, because I have other matters, no? It will be shared amongst all your friends, the colleagues who will be suffering. Anyways, I think this is a case for dismissal right away.
At least one
Mr.
post to me, my lord.
Oh, for what?
Just go to the wet provisions, my lord.
The only opportunity is by 2 o'clock. To withdraw. Don't open up a Pandora's box. This is a case for withdrawal, not to file. You were lucky enough to issue a notice upon before. The other court was lucky. The council was lucky to get a notice. This is not a notice.
That case, my lord, grant me, allow me to withdraw, my lord.
Better withdraw. Because the moment you do it, if other matter, if by chance comes back to me again in a week's time before vacation, I will satisfy myself of writing on this thing.
Bench 3,
Because in those matters, excess is not party, my lord. That is,
Eh?
in those matters, excess is not party, my lord.
Who?
In those matters, in the repetition that I have annexed in the order, my lord, that excess is
No,
not a party, my lord.
subsequently implemented. yes.
Okay, Mr. NJ, I heard Mr. NJ Khatonia, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so. Mr. B. Gogoi, the learned additional advocate general, who appears on behalf of the Finance and Taxation Department, and Mr. R.R. Gogoi, who appears on behalf of the Excise Department. Full stop. The petitioners herein have assailed the actions on the part of the respondent authorities for retrospective recovery of VAT from the IMFL shops, and have also sought for directions for a writ in the nature of certiorari for setting aside the communication dated 3/11/2025 issued by the Commissioner of Excise Assam, directing all district commissioners of the state not to renew IMFL on-shop licenses for the year 2025-26 in cases where purported VAT outstanding remains unpaid. Mr. N.J. Khatonia, the learned counsel appearing on behalf of the petitioner, submits that the petitioners would not like to pursue the present writ petition. Taking into account the above, the writ petition accordingly stands dismissed on withdrawal.
This is a lordship. Lordship, the matter pertains to non-payment of contractual bills matter.
Which year?
2023, the work was started in 2019, my lord. And
Huh?
it was completed in 2023, my lord. Annexure 3, lordship, number 18, may kindly. The bills were duly submitted, my lord.
9th March, second affidavit by second.
It's
notice
IPF
went
for
out.
all.
11. You are paying for all the respondents.
not payment of bill.
Huh?
Payment of bills regarding use of vehicle.
Non-payment,
Yes.
vehicle.
Vehicle matter.
You have to get the money from whom?
Period.
Police. के बाकी वो सब करने रहती है Miss Yudas. Miss Yudas, there's one more matter of
Yes,
that.
my
Yeah,
brother has said.
I put your name because then there won't be any.
I'll take steps, but.
We can put his name in this matter then.
Well.
His name. Ito 9th of March and 2nd of March filing affidavit.
Well. Very pleased on this, my lord. The matter related to the shifting of the petitioners, my lord, India made four liquor shop from one place to another place with the district lot. Here, page 24, my lord, the proposal after making inquiry, proposal has already been forwarded to Assam Commission of Exile. Assam, my lord, by publication dated 10/40/2025, my lord. But in spite of, my lord, the matter has been forwarded, nothing has been done as of now, my lord. The similarity is already dealt with by the coordinators of this honorable court. This honorable court disposed of the same, the page 45, my lord.
Lordship, I'm
They
appearing
passed
for
similar orders. Where is
Sim-
Mr. Arago?
similar order.
I passed a similar order.
Yes.
Where is it?
Yes, sir.
That day?
So page 45 also, my lord, coordinated, so page 45 is also similar. Page 40. There is no order passed by the, my lord, coordinated.
This is under 270/94A, nah?
Yes, sir, 294A, 4, we didn't make it 2, we didn't make it small c, we didn't make it Roman.
You are a standing council of the excise.
Yes, Lordship.
He
I'll
passed
obtain
a
instru-
similar order. You consider his application.
No, Lordship, I'll obtain instruction.
Why
Lordship,
do you
from
want
the
to obtain
department.
instruction unnecessarily spending time out here?
Kindly 4 weeks time may be given, Lordship.
Absolutely no. We dispose it of. Same directions will be passed. I've already passed them in view of the Commissioner of Excise directed to consider the proposal submitted by the Office of the Deputy Commissioner for shifting.
Yes.
Who has submitted the proposal?
Yeah, page 44.
Page 44. It has been submitted by District Commissioner Kukrazar. Consider it and within the stipulation of so and so. Hedna moi eta order pass korisu Bijoy dise, not this one, the other one. Same order. Disposed.
Fine.
Just go in. So can do order pass. Can you do order pass? License. What?
Please, your worship. My lord, a market which was settled with me, my lord, in 2022, the lordship will turn to page 24.
Age?
24, my lord.
Yes.
So it was settled for 22, 23. Regarding 22, 23, 24, my lord, it tender was called for.
Hmm.
So ultimately, my lord, that tender was not subsequently accepted. That tender was next year, my lord, for 23, 24, my lord. Tender was not accepted. On the basis, a letter has been issued by the SP that tender should not be given in the bordering district market bordering international border. That thereafter, my lord, we challenged it by filing a writ petition. Your lordship will turn to page 27.
Hmm.
No, my lord, that is not 27. Your lordship will turn to page 39. Page 39. my lord.
Notice.
Page 41. Page 41, my lord. Last paragraph. Page 6, page para 6, my lord. So that order of the SP, my lord, was suspended.
Yes. Then
Thereafter, my lord, I am running the market. They did not settle, but I ran the market.
how?
On the basis of this order, my lord, they did not, subsequently, they did not call for the tender. And now.
Then that
what-
writ petition was
now I-
dismissed.
Now what happened?
Was issued for settlement for the year Iman, which was period had lapsed.
What happened, my lord? Now also, they are not calling for tender. when they are not calling for tender, my lord, a market to be settled by tender, they are sitting over the matter, they are not tendering. So my lord, my humble submission before your lordship, I filed representation that you call for the tender. We are interested to.
Why you are asking for setting aside a notice dated?
9/6/20.
What is your prayer? Bari Mokha
My
tender.
prayer for either my representation may be disposed of, my, or the tender may be called for. They may be directed to call for the tender. Otherwise, what will happen, my lord? A market which is a market to be called for tender. They called for tender in 2022-23. It was settled with me. Thereafter, my lord, again tender was called for. That tender was not accepted. I came before your lordship. Your lordship suspended the order of the SP, that the SP has no power.
And and without the settlement, you ran the market.
Thereafter, what happened, my lord? After this, they did not call for the tender.
So how did you run?
I'm running, my lord. They are
How?
not interfering.
How?
They are not
No,
interfering.
isn't it a cattle market?
Yes, cattle market.
So cattle market without the DC's permission, how are you holding?
My lord, my lord. Thing is this, my lord. That is the situation, my lord. Let them explain how I am running, because I am running without any interference.
No,
and
you
they are
can't
not
run.
calling for
Is
tender.
it running?
My lord.
Are you running the market till
Yes,
now?
my lord.
You cannot run the market.
My lord, your lordship,
Where
It is the
without there
principle
being a
authority.
settlement, is it a private market?
not private market.
Then how can a public market be allowed to
My
be
lord,
run by somebody?
Your lordship will consider.
No, I won't consider.
Thing, doing by the
Absolutely
DCC.
no. You are on one hand, you are asking.
I am not asking before your lordship.
No. You see, further it is prayed that pending disposal of the petitioner may be allowed to run the Bari Makha cattle market. So are you running the market or not?
My lord,
If you are running the market, you cannot run without there being a tender.
my lord, I cannot run the market.
And if you are running this,
Well,
the DCA, who is to do? You have no
Let them
business on.
explain, my lord, why they are not calling for tender.
You have all means
I'm
the.
ready to submit tender.
We
my
asked the
lord.
district commissioner. Yes, madam. Are you? Mr. Setia, you kindly take it up and you appear for 4 and 7.
4 and 7, my lord.
You appear for 4 and 7. Just give me an instruction by next Wednesday.
Yes.
How on earth a cattle market is being allowed to run without a tender? You also. You cannot allow somebody to run. What is the market? The Secretary of Markets and Fairs.
Lordship,
It is
please permit,
unheard of.
Lordship, if we look at the prayer, Lordship, the prayer is for setting aside of the notice dated 9/6/23. Perhaps that is infructuous in nature, Lordship, because that notice was for the settlement of the year 2023.
Mr. Council, first of all, you should read your file properly.
Lordship.
That is the second writ petition, the first writ petition which he is enclosing as Annexure 1. Read page 10 of the
Lordship.
actual writ petition.
Lordship.
Read it properly.
Lordship.
Don't come up before this. Okay, we issue a short notice. Issue notice making it returnable on 17/12/2025. Ms. Nbora accepts notice on behalf of the respondent number 1. Mr. M. Setia accepts notice on behalf of the respondent number 4 and 6 and 7. 6 and 7 also. And Mr. So-and-so accepts notice on behalf of the respondent number 2, 3 and 5. The petitioner herein, extra copies of the writ petition be furnished during the course of the day. The petitioner herein have sought for a direction upon the respondent number 5 to issue a notice inviting tender for settlement of the Bari Makha cattle market, bracket, Singra, SINGRA, for the period from December 2025 to 36/2026. And further, also so prayed that pending disposal of the writ petition, the petitioner may be allowed to run the Bari Makha cattle market. Full stop. Taking into account that the petitioner have sought for such a relief, this court inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner is presently running the Barimaka cattle market. It is being submitted that the petitioner is still running the Barimaka cattle market. Full stop. Taking into account the provisions of section 10.
Lord, I run the market from last Monday.
Are you still running or not?
No, my lord, from very late to social. Last Tuesday, my lord.
Huh?
From last Tuesday, my lord, I am not running.
Last Tuesday.
Yes, my lord.
Ah.
From 9th, my lord. Before that, I ran.
Was running the cattle market till
Up to
9/12/2025. Full stop.
Up to 8/12/2025.
Up to 8/12/2025.
Yes,
Then why did you file the writ petition on 3/12?
my lord.
Why did you file the writ petition on 3/12? If you are running on 8/12,
8/12, I am running, my lord.
then why did you file the writ petition on 3/12?
My lord, I am running, but they are not calling for the tender. That is the thing.
But you are running without a tender.
I am running up to 8, my lord. They are
Was running
some
up till
other tender.
8/12/2025. Full stop. Taking into account the provisions of section 105 of the Assam Panchayat Act 1994, this court inquired with the councils appearing on behalf of the respondents as to whether a cattle market can be permitted to run without any tender process, which has been tender process. Full stop. Further to that, this court also seeks instructions from the respondents as to why for the year 2025-26 there has been no initiation of any tender process.
Regarding, my lord, subject to correction by your lordship, that Panchayat Act does not apply to Boro area, this BTC.
Why we made the panchayat a party?
My lord, no, my lord, Panchayat Act does not apply to BTC area, my lord.
Let us see. I have not said that whether it applies or not. We'll see when.
Your lordship refer to section 105.
Yes, we'll see whether it applies or not.
Oblige your lordship. That's all.
Subsequent litigation, on the stems of the order passed by the Honorable Court, by the order of the 21st November 2025.
Yes, what is the reason?
My lord, not taking any decision for reselection of the petitioner by the respondent number 7 and 8.
Madam, that day, in that matter, you remember, I heard it on rule clause 12 and all. I
Lordship.
passed that order. I did not interfere on the basis of rule 12, clause 12 or clause 1 of the executive order of rule 47.
Lordship,
The reason is there was no settlement for the last 3 years.
Lordship.
So therefore, I did not interfere there. But I interfered on the basis that he did not submit the mandatory police verification certificate.
Lordship,
And that being a mandatory condition, it
Lordship,
was unfair on the part, so therefore I set aside that settlement on
Lordship.
that basis,
Lordship.
not on the basis of that rule 47.
Rule 47.
Because when I looked into the file properly, I could see that.
Lordship,
Yes. I passed the order yesterday. I think it has been uploaded.
Lordship,
Seven.
Lordship.
Yes, what is it?
Here in this case, is the respondent number 3, Chief Executive Officer, has passed an order dated 9/2/2000,
Page
2/9/2020, page 39, my lord,
39.
39, my lord,
Yes.
page 39.
In the process for Kandigura witness 3 bidders, Mintu Ali, Minan Ali, Babu Talukdar. Okay. Where is the highest bidder? Mintu Ali. submitted all required documents except the balance certificate. When governments have prematurely allowed Babu Ahmed to operate the market without completing their mandatory iman. The GPC is directed to ensure the following: form the iman within 3 days. With the proposal for approval to the office issued us. Okay, now this is the order by which it has to be given to Mintu Ali. That is you.
Yes.
Or to
Mintu Ali and
Mintu Ali. Oh, I remember now.
On that day,
Yes, you filed together.
two
Yes, yes, yes. Now you withdraw. Now tell me.
My lord, so Chief Executive Officer Kamrup Amindia has passed the order directing the respondent number 8 to comply. But he failed to comply to the order passed by the
Huh?
respondent number. This order, page number 39 and page number 40, my lord, NSL 5 and 6.
Now they are not giving it to you.
No, Your Honor. So this requisition may be disposed of, directing the respondent numbers 7 and 8 to comply the order.
And what is this corrigendum?
Madam,
What is page 39 and what is page 40?
page 40 subsequently, another order was passed.
For?
Corrigendum order.
This is weekly market, the other one was daily market.
Daily market.
So here it is being allowed to be given to whom? Minar Ali.
Minal Ali and Mintu Ali, both the petitioners separately.
No, no, earlier it was given to Mintu Ali.
Yes, but Mintu
Now
Ali
what do you
was-
want here?
This
both
one is
the
Minal
petitioners,
Ali.
Mintu Ali and Minal Ali were considered by the Chief Executive Officer Kamrup Amindia. But the respondent number 7 and 8.
Withdraw, cancel and recall the selection process and select is conducted and prepared by him for allotment of all the weekly market. This is weekly market.
Weekly market and.
So therefore, if it is a weekly market,
Weekly
you
market
have
for
Minal
Minal
Ali.
Ali.
So your basis is of that order, which is the corrigendum order,
Corrigendum order.
page 40.
Yes.
Why are you referring to page 39?
This 39.
39 has no relevance with you.
Yes, earlier order was passed and that subsequent order has been.
No, 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 Mr. Counsel. 39 is for daily market.
Daily market.
This one is
40 is for weekly market,
Weekly market.
isn't it?
Yes, ma'am. I'm sorry.
So in daily market, Mintu Ali is chosen.
Yes,
Weekly market, Minal Ali
Minal
is chosen,
ma'am.
isn't it?
Yes.
And here the petitioner is Minal Ali.
Minal Ali for
So your case is out here is for weekly market.
weekly market, madam.
You have must have filed another writ petition.
Another petition subsequent. 15.
No, no. Have you filed another writ petition
Yes, ma'am.
today?
Yes, madam. It is
next
one.
item.
Next one.
Next
15.
item.
15
Next
madam.
item. Lordships.
I was directed to file efforts.
Now what do you want?
I want to get the direction to the respondent number 7 and 8 to comply the order passed by the respondent number C, Chief Executive Officer Kamrup Amindia.
Who is 7 and 8?
7 is the President and Secretary of the Gaon Panchayat.
Secretary, you are appearing, na?
Lordship. But President, I am not.
And 3 also.
I am
And-
appearing for
Moreover, my lord, actually the secretary concerned actually did not comply the order. Besides, he demanded some money, and subsequently FIR has been lodged against him. That FIR was not registered, and subsequently a prayer or complaint made to the SP Kamrup Amindia.
Okay,
That-
issue notice returnable on 7/1/2026. Miss Enbora accepts notice on behalf of the respondent number 134
Chairman, Lordship.
Four.
Lordship. 8,
6
6 and 8.
and 8. 7 also.
Lordship.
7 and 8. Oh, that's the
Lordship.
one.
Then 7 I am not. That's it.
No, no,
Because
no.
it's
You can
elected.
very well appear. Otherwise, it makes no sense. Again, asking him to do it. Okay, 6 and 8. Huh? Mr. M. Setia accepts notice on behalf of the respondent number 5, 2 and 5. Extra copies of the writ petition be served upon the learned counsel who represents the respective respondents. As regards the respondent number 7 and 9, the petitioner is directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein had participated in a tender process for the Kendukona weekly market along with various other bidders. In respect to the said weekly market, the petitioner was the highest bidder. And the respondent number 3 had directed the respondent number 7 and 8 to issue the settlement order in favor of the petitioner. However, the respondent number 7 and 8 have not taken any action, in spite of the fact that the said order issued by the respondent number 3 was issued as far back as on 19/9/2025. It is under such circumstances the petitioner have therefore approached this court. The counsel appearing on behalf of the respondents, more particularly the PNRD department, shall apprise this court as to why the communication dated 19/9/2025 issued by the Chief Executive Officer of the Kamrup Jila Parishad have not been adhered to by the respondent number 7 and 8. List accordingly. Second to week daily market.
Then 16.
Please, Your Lordship. My lord, the present matter pertains to illegal collection of the penal damage charges by the railway authority. A previous similar matter, my lord, have issued notice in this matter, my lord. The illegal penal damage charges was imposed by the railways upon the Food Corporation of India, and subsequently it was deducted from my work payment, my lord. Hence, the petition has been.
What order? Where is that order? You enclosed?
No, my lord, that has not been included.
In that case, my lord, other case notice
You have
was
filed
issued, my
affidavit?
notice was issued, my lord.
We take this matter with that, you file your affidavit. So what happened on 10/11?
My lord, we have received the copy of the affidavit in opposition filed by the railways.
So when is the next date fixed?
My lord.
Next day, I think that it coming up on,
December, it should be
If the matter had come up.
is coming up on 15 December.
15 December.
That other matter is coming up on 15 December. We will also be filing affidavit in opposition by Friday in that other
in
matter.
that matter, no? So let us have this after vacation.
Yes, ma'am.
And then you, on 15th, you inform the court to have that with that.
Yes, ma'am.
Itu ek order kori, the same order, but make it issue returnable on 2nd of February, 2025. H. Gupta, appears for respondent number 1, 2, and 3, and Mr. B.K. Singh appears for
4, 5,
respondent number
6,
4
and 7.
to 7. Extra copies by tomorrow. it will the affidavit to be filed by on or before, let us have it on 4th, affidavit to be filed on or before 2nd of February.
Much obliged, my lord.
He ordered to last year, huh? What is this?
May it please your lordship. Lordship, this instant matter is with regard to a registered firm of which the petitioner is the proprietor. He's also the contractor under the Panchayat and Rural Development Department, Assam. He's also representing 34 other firms. These firms have a common interest in the subject matter because they have carried out certain work allotted to them. They have supplied various materials to the DRDA and Albari, but payments have not been made for the requisite work done. And even after repeated representations being made, letters and correspondence being made from the petitioner's side, this instant petition therefore lies before this honorable court. Lordship, based on this, the government had also constituted a committee, the state level scrutiny committee. And
Contractual bill pertains to which period?
Lordship 1997 to 2001.
How can we look into that?
The petitions have also been filed in 2009. Those have been disposed of, wherein the honorable court had said that to adhere to the law laid down in Kamsher Ali case.
How can Kamsher Ali be followed?
Lordship,
PNRD doesn't have a chronological list. Do you have?
Lordship, the government has admitted the liability. There is no dispute with the legitimacy of the payment. There is no.
Where is the admission of the liability?
Lordship, may kindly see page 61. Page 61. Lordship, 16. Please, Lordship, Nalbari. The committee, after examination of all the relevant papers.
61.
Yes, Your Lordship. Lordship, the
Who has
last-
given this?
Lordship, the last row, Nalbari.
Huh? Whose document is this? State level scrutiny committee. This was done when?
Lordship, in 2014, it was.
Where we are looking into?
Lordship, page 60. In 2014, this committee was constituted.
12 crores, so and so, so and so, so and so, principal interest and so and so. 19 lakhs. How much? 12 crores, 34 lakhs, 75,000, 197.
Interest in 2014.
Supply materials due. The committee after examination of relevant papers and in view of the comply with the High Court verified. Passed in WPC numbers so and so on different dates and payment of rupees as principal together with interest accrued thereon on so and so till the month of August 2014. And all total rupees so and so is recommended for payment. Okay. This is by the member SLC and senior finance accounts. So this was done when?
2014, Your Lordship.
Then
Lordship, in 2017, upon the prayers of the petitioners, the budgetary provisions were also
Then what happened?
paid. They have repeatedly, budgetary provisions got lapsed.
What were you doing for all this while? 2011 years have gone by.
We have sent representations, Your Lordship.
No, representation doesn't work before me.
Lordship, I'd like to draw your attention to
Division bench helps solve these things. I don't. I need only
Please,
to dismiss this type of matters.
Lordship. Lordship, will kindly come to page 18.
Representation won't help it.
Lordship, the authority has.
Hello, we dismiss it. What do you say, madam? We dismiss it. Payment was to be made as per Kamsher Ali. That order cannot be complied with because you don't have a chronology list. It was the finding of fact arrived at in the year 2014. We are in 2025. Why should we at all look into it? By normal order, we follow, we dismiss.
Just due to their inactions. it
So
is
what?
their-
Dismissed.
Lordship, page
Yes.
84.
Can't help it. You were waiting too much.
If I may come for a moment, Lordship. Page 84 may kindly be seen for a moment, Lordship.
Page,
It was page 84. ICB projects. Lordship, we had been communicating that part of fault is that Lordship, the budgetary provisions, they could not make it proper point of time and they did not have the fund allocations. Lordship, may kindly see page number 84. It was given by the commissioner to the principal secretary. With reference to the letter on the subject cited above, I would like to submit the proposal for an amount of 5 crores only, Lordship, for the clearing outstanding bill past liabilities for the period 97-2001. This is in respect of the petitioner above. In this regard, it is stated that an amount of 12 crores is past liabilities in respect of Bipur the present petition, Lordship. And 34 forms under DRD and Alberta district regarding payment of past liabilities for the year 1997 2000. It may be stated that the state level scrutiny was constituted by government notification this and this 29/8/14 to examine all the relevant papers to comply with Honorable Guwahati High Court's order verdict dated this and this. The Lordship, the 4 writ petitions which has just been mentioned, recommended rupees 12 crores.
what is the basis of giving you interest?
Lordship, this was because of the fault made by the authorities. That is one.
So what?
letter. Lordship, there is a recommendation by the authorities.
No,
and
no.
the Judgment, Lordship. I'll just take. my lord to
Commendation
that
of
relevant
Indian
paper.
interest of 7 crores.
Lord-
My goodness. This board can't be a party to all this. Go as per Tamsir Ali, that order cannot be worked out.
Lordship, in the year 2024, because of this. fault,
In
Lordship,
view of
the
that,
funds were
what is
not
the
there.
direction? It is admitted at the bar such payment of the contractor's bills and manner and method to be dealt with in such case has been rendered by the full bench in so and so. In view of that, the petition is disposed of with the direction, the petitioner as well as the respondent shall be bound by the principle of law and the directions as passed by the full bench of this court and assert shall deal with the grievance as per the directions rendered above and pay the amount to the petitioner to which they are entitled to. That,
And my lords will see.
they don't have the system of chronology.
Lordship, at page number 87, they admit that the report was not received from the SLC, so that they could not make the payment. In the year 2025, January, they say so, Lordship.
Where is the right of your interest?
Lordship, they have admitted that. That's
Where?
their interest. Lordship, that is their letter, Lordship.
So the interest cannot be given like this, 7 crores, my goodness, what is wrong? Yes, you are the person, you are the person who is main, the cause of concern. Commissioner of Air, the commissioner writes this letter that pay him 12 crores. You are paying that, the total interest is 5 crores, total amount is 5 crores and you are saying to pay 7 crores as interest as on 2014. And if you admit this interest, this will go to, this is another 11 years.
Let's say we'll take instructions. We'll take instructions.
You don't want a dismissal,
That's it.
huh?
That's it.
You did not
That-
just for dismiss it right away,
That's it. That's it.
huh? I think we should dismiss it.
That's it.
Lordship, it is on the part of their authorities, Lordship, the funds were not there. They came up.
So what, why 11 years they are waiting? No, forget about representative, can by way of representation, you can extend the period of limitation.
There of actions.
You can't even go for a contempt as of now.
Lordship, Lordship, that.
No, the verification is done at page 61.
Page
Kindly look
61.
at this amount.
Page
It's
61.
phenomenal. 5 crores is the principal, it's okay. But they are putting an interest at 7 crores.
That's it.
By the office.
Huh?
They are all by the office, the respondent, this is not accepted because
I think this particular IS officer should pay the interest. Huh?
It's okay.
Let this.
What do you say? Commissioner, secretary? Huh?
Lordship, even we have suffered. Lordship, will see kindly page number
No, this is not a case.
92, Lordship. For a moment, just I'll refer to my lord's attention, my lord.
I'll
There are
issue
some
notice, okay, I'll issue notice, but I keep the question of maintainability of the writ petition on delay and latches
I'll
open.
satisfy, Lord.
by this letter
Because you can't, it is only on the basis of that letter issued by the commissioner, which has
Lordship.
now led to this,
Lordship.
this admission of 12 crores.
Lordship.
On one hand, you say the panchayat has no money and you are just, your commissioner is just spending money like anything. What do you say, Mr. Gogoi, finance? No, you see, 1997, 2001 is some claim of 5 crores. Direction was passed when Justice Animat Hazarika was there. At that point of time, they filed the writ petition after almost 10 years, an order is being passed, follow Tamser Ali. Then they make up a verification. There is no direction for payment of interest. They verify and say that 5 crores on principal they are entitled plus interest of 7 crores is paid. This was done in 2014. No, by a committee. State level. What is that? State level?
State level.
Page 61, Lord.
A state level scrutiny committee.
Scrutiny committee.
And this has the, where the commissioner was there, he himself gives interest. Although there is no direction for interest. He gives interest at twice the amount, more than twice the amount. Then thereupon, that happened in 2014. He keeps on submitting representation after representation. We are in 2025. Writ petition is now being filed. Now, 2024, this very commissioner, I don't understand, what is the problem with the commissioner PNRD? Writes a letter that 12 crores is due. We have in our head of account 5 crores. Why don't we pay that amount?
Lord, if I may raise one more attention of my lord at page 81, the interest issue comes over from here, Lordship. The issue of interest comes from here, Lordship.
Issue
Page
of?
number 81. This is by the additional secretary to the government, Lordship. He writes that the interest has to be paid.
Release of past liability of the payment of in respect of Vipul Lekars.
Honorable Court has also directed release of.
Representative of 34 firms. See,
34 pounds.
this is all claim of 25, 34 firms. They are having all cumulatively, everything is being taken up.
The problem is that how the committee was constituted.
No.
Probably they were given, my lord, takes us, that will have to.
And they say that this is the amount. Now this, they don't forget that this is the principal plus interest as on 2014.
And Lordship.
If you admit to this 12 crores, then you will be also admitting to the interest from 2014 onwards?
If I may refer to one of the Supreme Court judgment, Lordship, Purnima Atmani 2025 INSC 262, it says, Lordship, in now when the matter, money has been withheld by the state, they are entitled for interest. Lordship will see 2025 INSC 260. I made a petition, categorical judgment quotation at page number 32, Lordship.
What does it say?
But it says, if I may take, Lord, page 32, Lordship. The Honorable Supreme Court in this and this observed that the interest is normal accretion on capital. It is further held in para 25 that if on facts of a case, the doctrine of restitution is attracted, interest should follow. Restitution in its etymological sense means restoring to a party on the modification, variation or reversal of a decree or order what has been lost to him in execution of decree or order of the court, or in direct consequence of a decree or order. The term restitution is used in 3 senses.
Where is the decree?
Worship the Tamsir
Where is
Ali,
the
sir.
decree?
Worship order of the.
No, there is no decree. Tamser Ali did not say anything. They carry out verification and pay as per Tamser Ali.
But if I may refer to Tamsir Ali, Lordship, it says that the limitation issue is also not taken because it was Jatin Pathak's case which.
You have to
went the
understand,
division
Mr. Betala, the limitation as regard Tamser Ali was not the question because it was a consent order passed by the court.
No, Lord, if with great respect, Lordship, I'll take my lot to that paragraph. Lordship, the issue of limitation was also dealt with Tamsir Ali. Lordship, I have a copy. Para 14 says that in that case, when Jatin Pathak case was there, this person.
Give me
was not-
Tamsir Ali.
Lordship, just please.
Finance is not party here, my lordship is the president.
Finance is not party. I am drawing only the attention of finance to the problem they are going to.
The following one is the bill versus two by one.
This is not done. Yes, where is it?
Lordship will kindly have the para number 1, Lordship. This batch of writ petitions, if I may start, my lord, at here. Page number 2 of the judgment, Lordship.
This.
Even this petition was brought by limitation lawsuit, which was with Kamsher lawsuit before the division bench. And that was the issue raised before the court, that limitation would cover. But here the court says that no, under 226, that doesn't lie. Then, my lord, if I may draw my lord's attention, para 16, lordship, the answer of that limitation issue has been dealt here, lordship.
No, 66.
No, paragraph 17,
16, lordship, 16 and 17, lordship.
17.
17.
So-
lordships.
That case, I think this is on that we dismiss your petition.
Lordship will issue notice that, because Lordship says that, Lordship will issue notice in this case.
No notice.
Lordship, for the legitimate reason in the year 2005, they got, well, they themselves admit that the budget got lapsed, and 5 crores they have already admitted that it has to be paid to us. That amount of 5 crores, Lordship, that is the legitimate amount for that. That would inspire my lords on.
Now it has been stated that now, the honorable court has also directed to release the principal amount along with interest.
That just I have brought.
Where is that? That is what, no, that is what I see. This seems to be some concerted form of some problems. These orders, these are serious things.
Lordship.
No, I am therefore shocked because none of the orders passed earlier said anything about interest. Neither Tamsir Ali says anything about interest.
In page 60 of him, has been stated that due to absence of representative from finance department and CBDF department, the second meeting was held on site. In this meeting also no representative from the department. Now.
Page? Huh? 60.
Procedure.
Bas.
Now, so finance is 2 and 3 is not there. So what decision is this by the executive engineer, joint director and commissioner? Let the PNRD commissioner pay. You pay from your own pocket.
Let's say for that, we'll take instructions whether they pay or not. I'll take instructions from the commissioner. So Lordship notice may go now.
Let the division bench take a call.
Lordship,
Let me dismiss it.
no.
Let the division bench take a call as to whether such code permission is permissible or not. Let the division bench, you have better merciful judges, they will consider, I don't know, they are.
Well, I'm just inviting my lord's attention at page 87.
Mr. Vedala, the question doesn't arise. First of all, why on earth did they incorporate the interest? It shocks me.
Lordship.
This is shocking. This is a case of, which shocks the
Lordship.
court. Where the court directed payment as per Tamsir Ali after verification. They verify in 2014
14 lords.
14.
and on that very day imposes interest. So let us assume Tamsir Ali is applicable. Tamsir Ali also mentions it that they will verify. Once it is verified, it is quantified. Then how do you incorporate the interest immediately thereupon? Now, Tamsir Ali paragraph 17 says, 16 and 17 say, you see, the agreement amongst the parties were, more particularly clause number 3, that they have to file the writ petition within 3 years. This was said that don't come and put a limitation out there because it's a public law remedy.
Public law remedy.
There's no quarrel with that. But the fact remains that today it becomes difficult even for carrying out any form of verification in respect to any supplies made from 97 to 2001.
When
Unless the PNRD department say that this particular, because this is not a notification, this has been done, this verification which is being done is not a verification done as per the order of the governor, whereby there is a question of quorum being met or not met.
Lordship.
Quorum would be 3, can be done. But what they did is, they bypassed all the finance department who are there, number 2 and 3, and they went ahead and made this.
The the point of view.
Previous case, I think we should dismiss.
Lordship, I'll just drop.
And then you go to the division bench, and the division bench, if you are not lucky, Supreme Court 100% will give you that as per Purnima. There's another judgment somebody that they produced out there. I have it. That in these type of cases, the court should not issue. Anybody has that judgment? A Supreme Court judgment which went from Guwahati. Karbi Anglong case.
Well, I'll just assist my lord on the very foundation the lordship has held so. Lordship, the only consideration is that even after budget, lordship, the budget account has already been prepared by the finance
No,
department.
but Mr.
Lord.
Mr. Biralar, first answer me. Your basis is the verification which was carried out in the year 2014. This verification is to be carried out by a committee of 5 by the governor.
Right.
They take a decision that look here, we have called the finance is not picking up the phone or not coming. Let us go ahead and make the verification. Now, does the notification by which the governor fixes that committee gives a leeway to the other members to take up the issue that 3 is the quorum? Forget about the finance, they are in the minority, so we overtake them. Is it permissible as per this notification? If it is permissible, good, you have the proper verification. So there is no verification.
Page number 59, here again, the finance has appeared. Lordship, page number 59, finance appeared, then again they approve this.
No. These are the two representatives, are representing for finance and senior finance. These 2 persons are not there.
Lordship, that is what, Lordship, the another 29 August 2014, your Lordship will see. For disposal of the various past liabilities, commissioner, representative of finance department, senior finance accounts, executive, everybody is there.
No. So this is not there. He is the senior finance and accounts officer of the commissioner at PNR. So number 2 is not there.
A representative, Lordship, it's there. Page number 59, Lordship.
Where is number 2?
Lordship, a representative of finance department, Lordship, member.
Who is he? Isn't this the particularly categorically mentioned that we went ahead without that finance at page 60?
The first meeting it's page 59, if I'm referring, Lordship.
Understood. What is
Yes,
page 60?
Pursuant to this also, Lordship, they went ahead with, your Lordship will see that budgetary provisions order, this letter. Lordship, there they say that they have proceeded with the finance also. Then they come and make a head of.
Where is the finance approval taken?
March 2025, Lordship.
Page?
Page 6 March, page 92, Lordship.
Yes.
Okay. With reference to the letter on the subject, I would like to submit here with the proposal of 5 crores for clearing the outstanding past liabilities for the bill of 97. In this regard, it is stated that an amount of 12 crores in past liabilities of this and 34 members of the firm under DRD and Nalbari regarding payment of past liabilities for the year 97-2001.
This is by Commissioner PNRD to the additional Chief Secretary PNRD.
Lordship,
Where's the
page
finance?
number 93, they have made the heads of account. During the financial year, there is a budget provision for an amount of 5 crores only under the head account of this and this general voted Lordship. Lordship, this has come from the finance department. Heads of account and the approval of the budgetary payment always come from the this department of finance. And once, my lord, they have come in the year 2020.
Mr. Vetala, if this submission was made by your colleague who is sitting beside you, I would have said that, okay, she may not know. But it doesn't look nice on your part to say that the head of account is being created so and so. Every department has a head of account for its expenses. So the money will come to that head of account. It is not for this. A head of account is created. This head of account is already there. This head of account, the head of account so and so, general. See, this is how they say that 500 lakhs we already have in the head of account. From there, let us pay them. This is what is being said. This is not that finance has to create the head of account for everybody. Tomorrow, if you have a compensation claim, it will come from a head of account, which is there as regards the compensation claims. There's already a marked head of account. In certain new things, which has happened for the first time, then they may have to create a head of account. Then you need the creation of the head of account, and in that, the financial sanction will be done to be paid to that amount. This is
Lordship, but basically the issue remains that, Lordship, the amount has been legitimately withheld by the authorities. Had it been my fault on my part that I'm not pursuing with the authorities, Lordship, they have gone wrong. Well, in that case, I could have been proven wrong, Lordship, because I have.
you should not have waited so long.
These representation at page number.
No, Mr. Vitala, you are an expert lawyer in service jurisprudence. You are an expert lawyer in contractual matters. Isn't it the law laid down by the Supreme Court from time and again saying that you can't wait? You cannot, maybe there is no limitation being given, but then also you cannot act as a Kumbhakarna or a Rip Van Winkle, just wait out there and not do anything before the courts. You went out there, followed okay Tamsir Ali. There was a verification without the finance, maybe, but then also you are just pursuing for the last 11 years and have come at the fag end of December. That too when this court is sitting. That is.
That's why when a member of the PW department was made a party in the committee, he was not there.
Where?
Purpose.
Page 59. Executive engineer to be nominated PWD. Ha, he is not there.
What is the purpose? It's the technical person. We will know whether that is done. Without the absence of the technical person, in the absence of the technical person, they should get it.
But otherwise admitted.
I think we need to close this chapter for once for all today itself.
And
Means not to even go to the civil court also.
And Lordship will.
Because there is no verification. And you can't verify now.
And Lordship, more particularly, my lord, it is not the petitioner who will have to see, my lord, how the authorities has been doing their works, my lord. My lord, I standing over here, I can only make my verification of it.
Mr. Vitala, you have to understand.
Lord,
This person concerned is filing for 34 firms. 34 different firms as an constituted attorney.
attorney.
Who are the 34 firms?
Lordship, I've mentioned it. I've mentioned all the 34.
All are parties.
My lord, I've constituted as a representative of all these 34. My lord, I have made a.
Who are the 34 firms?
Lordship, page number. See 26, Lordship. The
Huh?
name of the 34 forms are here. Page number 26, Lordship. Part of the petition, Lord. It's in the paragraph.
Chalo. We issue notice, but we will issue notice provided you first produce the work orders of all these 34 firms.
Indicate in the letter. In the
Yes.
order, Lordship.
No, then only additional affidavit bringing on record the work orders, completion certificate, as well as any running bills being raised, all these things by filing an additional affidavit. Then we may ask them to issue a notice.
Mail.
What do you say, Mr. Gogoi? PWD is not a party. That case, let me come back. Give me a thought for 5 minutes and then whether to issue notice or not, or adjourn it or dismiss it. Today I have not been able to dismiss one from the morning, huh?
Take that stand. Tomorrow, without the stand, it would go to the, even for, I'm saying, the worst scenario is it goes to the division of the company. We must
The division bench allows you to file a affidavits even in writ appeals.
Oh.
So you have the option.
Lordship, let this
You have a
be an
very kind
inquisitorial
division
litigation,
bench.
Lordship,
That
let
is
it
why
be
I say,
inquisitorial. As my brother has suggested, Lordship, let it be an inquisitorial, Lordship, it may help either of the parties. Because the claim, Lord, as of now, Lord, had it been the case.
no, I'm not satisfied. Anyways, I'll write everything. Then only I'll issue notice. I'm coming back in 5 minutes. But I'll say that the verification cannot be taken into account. That is my prima facie. Issue notice making it returnable on 16th of February 2026.
My lord, one more, my lord, on the maintainability point. My lord, the petitioner has been filed by one Vipul Deka.
Yes.
He, my lord, is the authorized representative. No authorization is there, my lord, to represent 34 contractors in the petition.
Page number 3, Lordship, down. I've made a mention.
Let me pass
Mention
the order.
And that.
My lord,
If you are not satisfied, then tell me.
my lord.
Mr. B. Gogoi, the learned additional advocate general, accepts notice on behalf of the respondent number 1. Ms. N. Bora accepts notice on behalf of the respondent number 2, 3, 4, and 5. And 7. And this one, number 6, you accept, na? 1 and 6. Extra copies of the writ petition be served upon the petitioner, upon the learned counsel for their respondents by tomorrow. The present writ petition is filed by one Mr. Bipul Deka, claiming seeking a direction upon the respondent authorities to pay an amount of rupees 12,34,75197 for the dues payable to 34 firms for works done during the period from 1997 to 2001. The basis on which the petitioner has approached this court is on account of is that the petitioner, along with one Sri Arun Das, and various others, one Sri Arun Das, and Sri Deepak Deka and various others, Deepak Deka and others, and Topon Bormon and others, have filed 4 writ petitions earlier in the year 2009, which were registered and numbered as WPC number 1418/2009, 1419/2009, 1448/2009, and 2234/2009. These writ petitions were disposed of sometime in the year 2009, thereby directing the respondents therein to redress the grievances of the petitioners of the said petitions. In terms with the judgment of the full bench of this court in the case of Tamser Ali and others versus the state of Assam and others, reported in 1998 4 GLT page 1.
2008 4G. 2008 4G.
2008 48 GLT page 1. The record further reveals that pursuant to the said judgments, said orders, a state level scrutiny committee was constituted by the governor of Assam by a notification dated 30/1/2013 of the following members. A page 55 or say, Commissioner PNRD's chairman, a representative of the finance department member, senior finance and accounts officer of the commissionerate PNRD department member, executive engineer to be nominated by the chief engineer PWD B department member, joint director, tech office of the commissioner PNRD department convener. The said notification also mentioned that the committee would cease to exist after 30 days of its first meeting. The record further reveals that subsequent thereto, while another notification dated 29/8/2014, another committee was formulated consisting of 5 members as was mentioned in the notification dated 30/1/2013. Full stop. On 30/10/2014, the committee so constituted, taking into account that none from the PNRD, PWD, neither from the, as no member from the finance department as well as the PWD department were present, proceeded to evaluate the documents as submitted by the DRDs and to prepare the report. A report thereupon was prepared by 3 of the members out of the 5 members, wherein in respect to the district of Nalbari, it was recommended that an amount of rupees 12,34,75,197 is payable for the supply of materials. This amount of rupees 12,34,75,197 was arrived at by taking rupees 5,31,21,936 as the principal and rupees 7,05,53,261 as the interest up to August 2014. It is not known from on what basis the said committee had recommended payment of interest, inasmuch as the orders passed by this court in the various writ petitions only mentioned applying the ratio as laid down in Tamser al Supra. The record further reveals that the petitioner thereupon revealed that the petitioners in the four petitions pursued with the PNRD department for release of the said amount. Full stop. It surprises this court to take note of a communication issued by the Additional Secretary to the Government of Assam Panchayat and Rural Development Department dated 19/10/2022, wherein a petition dated 25/8/2022 was forwarded to the Commissioner PNRD Department for release of the amount of rupees 12,34,75,197 under the DRDA on the ground that this court had directed release of the principal along with the bank interest. The record further reveals that from time to time, the Commissioner, PNRD Department have been writing the letters to the Principal Secretary to the Government of Assam Panchayat and Rural Development Department for release of the said amount. However, the said having not been released, the petitioner has approached this court after 11 years from the date the verification was completed by a committee consisting of 3 members out of the notified 5 members. This court also finds it relevant to take note of that at paragraph number 16 of the writ petition, the petitioner had referred to 34 firms for and on whose behalf the present writ petition has been filed. But there is no authority placed on record that the petitioner is entitled and or authorized to file the present writ petition on behalf of those firms. Considering the above, this court directs the respondents to bring on record their stand by filing the affidavit. The maintainability of the writ petition on the ground of delay and laches is kept open. The said affidavit be filed on or before 9th of February 2026. I think this is a case of a CID inquiry.
It will be conveyed now. It will be
You kindly take it up on that respect because
Well-
this is required.
Lordship.
Why I say so? Because this type of matter, this has caused such a big problem. If you
Yes.
realize there is another matter, other department I found out, where a person is not getting money in view of a direction passed by this court in respect to a certain amount to be payable to one contractor in respect to the whole contract. Did you appear or somebody appeared? In the entire, there were many features of various contracts. So all these contracts, this particular person says that I am the owner. I have done all this thing. Court passes an order.
Yes, yes, I was directed to appear there, my lord. Subsequently, my lord, while disposing the writ petition, honorable court said that you can take the money provided you furnish the bank
Bank
guarantee.
guarantee. Now,
He
he
never
did not furnish the
he
bank
never
guarantee and therefore, however, this
Yes.
person is not getting the money. So therefore, this is a very important aspect
Lordship.
which we'll touch later on
Yes,
that.
yes.
So that is why I said that particular bank.
Lordship, at page 26, they have already asked us to supply the bank accounts of all the 34 firms, which we have supplied, so that the amount.
Therefore, I'm saying now you have a you will get a very good affidavit from the Commissioner PNRD. Miss N. Bora is your helpful aid. You can also come this side on the next.
I'm grateful to the highly.
In. What? Contractor's bill.
Yes, yes. Case number 19 onwards, these are the work orders. After my bill were prepared, that the completion certificate were also issued. They are represented by board of approach. But we need the note.
Where is your completion certificate?
Page number 29.
Okay, notice issue as Bora appears for the GMC. This will be on 23rd of March. Affidavit by 16th March. As Bora,
19.
So, Lordship, this matter pertaining to non-payment of zero with the Lordship, non-payment of zero with the Lordship. Petitioner executed three work, Lordship.
Where are the work orders?
First, work by handing over the later Lordship.
Where the work orders?
Lecture 1 Lordship, page number 10 Lordship. The petitioner has submitted the letter Lordship to the executive engineer Lordship, three works order letter Lordship.
Where the work orders?
No, these are verbal contracts, my lord.
These are not work orders. These are all letters written by you. Where the work orders?
Senior contractor Lordship and the as one exercise Lordship issue the verbal work orders Lordship. And petitioner execute that execute the order Lordship. Then after petitioner submitted the legal notice Lordship.
So you are entitled to 10 lakhs. claiming 10,33,000. Isn't it? Chalo, it was same. 23, 3 or 16.
My lord.
23 notice returnable. 16th you file your affidavit whether the petitioner is entitled to the amount and when the payment would be made.
All right.
Lordship, here in this case, the private respondent has settled a bidding a tender of collection of disposal waste management. If Lordship permit me, out of 9 bidders have participated, and there is nothing remain. If page 10,
Page?
page 10 of my petition, Your Lordship. Page 10. Serial number 7.
Yes.
Serial number 7. He has participated with a bidding amount of 57,48,750. And the contract amount, contract at index of 4, Your Lordship, in Gem Hotel, page 40. $48,891. That is a tender bidding, estimated tender bidding for 3 years.
Where?
Page 40, Lordship.
48. Yeah, 48.
48, 40.
40.
Yes, Lordship. Estimated bid value is 48,86919.
Hmm.
And he has been settled by in page 72.
Yes.
Last column, Your Lordship, amount of contract 8127630. Without giving any opportunity to any participants, they have rejected, NFLO have rejected, and respondent number, participant number 7 has been allotted.
What opportunity is required?
Why our tenders has been rejected? There is no any issues of, as per the procedure.
You were
of
not
the-
informed in the same portal.
Lordship, it is, if Lordship permit me, there is a rules 7.3.
This is the letter of 25/11/2025. Performer time for extension. The stipulated date for completion of the work mentioned is why you have been rejected?
No, there is no one answer. NFLA, but respondent authority have to give an answer. And we have
What?
given an
It
application.
can't happen like that.
They are, my lord, it is there in the portal. They are informed in the portal. I have given, my lord.
Then
And issue remains is that Your Lordship, bidding amount of the respondent number 5.
petitioner name
L2,
Chandan
my lord.
Dehingia.
Chandan Dehingia.
The bidder has submitted contractual work completion certificate for the work 1 so and so, 2 so and so against GMC work certifying the value of the work completed till Iman as rupees so and so. The value of the work completed is more the required value of the single similar work amounting to of the advertised amount.
What is the balance sheet today? Little balance sheet, yeah, no.
These documents have not been submitted, Your Lordship.
It is there in the-
When
Gem portal, it is uploaded.
it
my
is
lord.
lottery 73.5 clause also. It's been, I have annexed here, Lordship, as per the annexes of the procedure of the contract issued by the NFLA. they have to give a reply. It is there in the annexer 70, annexer 6, your lordship. Circulation of bids short for documents, if it is anything there. Block number 7.3.5, that has been issued by the NFLU itself, you know. And they are bidding account private respondent more than the more than the estimated bid amount, your lordship, which have been settled to him, private respondent. Page 70 annexes,
Mr. Gupta, I don't understand the first one. What is this basis? The bidder has submitted contractual works completion certificate for work 1 and 2.
My lord.
Then again, GMC work number so and so issued by year certifying the value of the work completed till
No.
Iman as rupees 31 lakhs 5,000.
My lord.
The value of the work completed is more than the required value of the single similar work amounting to 35% of the year. So this is okay.
This is okay.
So therefore
But-
you are okay with it.
To certify that, my lord, they have to submit a audited balance sheet, which that they have not submitted, my lord.
So this is the requirement as per here, na?
Page 45, my lord,
Page?
45. The terms and conditions, clause 1.2, my lord, financial standing.
The bidder will be qualified only if they have minimum financial capability there. Financially, the bidder should have an aggregate financial of not less than 1.5 times the advertised bid value during the last 3 financial years and in so and so. In case audited for the last financial year and the current financial year of the date of the opening of the is not ready and certified by a charter accountant. In such a case, certificate will be issued on the basis of the government approved document like GST. Returns, VAT returns, clearly stating aggregate financial will also be considered. The banking reference should be for the scheduled bank in India and Sudaya. In case the bidder submits the audited balance sheet for the liquidity or for the last financial and the current financial up to the date of year shall only be considered. In the instance where the charter accountant certified copy is not available, a certificate issued by so and so year. Mr. B.N. Gogoi, did you not look into, what do you say about compliance to 1.2 at page 45?
No, sir, I am the standing bidder of this case, of this participation. I'm still there, and my extension have been done up to 7/12/2025.
It's okay, that is not the question.
No.
I'm asking you, did you submit this document at 1.2? I'm asking you that. Because that is the reason why had not submitted the CA audited balance sheet of the financial year 2024 and 2023 and 24 and 22 and 23.
No.
Where is that requirement of financial balance sheet is required? As per
1.2,
clause
my
1.2.
lord. That says, my lord, the audited balance sheet has to be submitted, my lord.
Where is that? In case audited balance sheet for the last financial year, bidders should have the aggregate Iman and
the
during the
last-
last 3 financial years and in the current year up to the year. The audited balance sheet financial certified by the surveyor with his stamp signature shall be considered.
My lord.
So 1.2 has not been, you have not done that.
No, sir, we have submitted everything. So now it should be mentioned, now I have came to know this report.
No, my lord, that is incorrect. It is in the GEM portal, my lord, before we finalize.
Right now.
No, the 2 pages which I have given, they have an opportunity to, my lord, represent before the authorities seeking time that they may submit
Where is
the
the
audited balance sheet.
Where is the opportunity
That
given?
the 2 pages which I have given, my lord, will see. It is only L1, my lord, who has submitted the representations. Review, my lord, if my lord, I'm on the right page, my lord, the EMD status, MSC status, evaluate, review. In the review, my lord, we'll see review representations is there. In respect of L1, he has only submitted the representation, my lord. So far as the petitioner is concerned, before opening, finalizing the bid, my lord, we have given him 2 days opportunity. Within that 2 days period, he could have represented to the authorities, my lord, praying for time to submit the audited balance sheet, which they have failed to do. Now the contract has also been awarded, my lord, to the successful bidder.
Hello?
The reasons were
No.
specified in the GEM portal, my lord.
What point I want to say, Lordship? If the bidding has been not been fulfilled as per the criteria of the GEM portal, let me give an issue. Now they have given to us. If it is
No.
there, then why should I come before this honorable court?
The reasons are notified in the GEM portal, no, this is the
We
incorrect
can do
submission.
one thing, ask him to put it on affidavit that it is there in the GEM portal.
Yes,
That's all.
my lord.
Then you'll be satisfied.
My lord.
Then later on, with question of stay doesn't arise. So this will continue.
My lord.
They will give.
We'll file it.
Or you can very well challenge this non-consideration. That is your lookout. Which one do you want?
Non-consideration. no
But you have to challenge that.
To challenge that.
problem. No, Lordship, I came to know later on, no.
So therefore, what is your course of action you are suggesting? Should I issue a notice asking them to file an affidavit that this is there in the GEM portal? Or do you accept that this is there in the GEM portal, but this was illegally done? Which one?
Illegal.
So therefore, you have to withdraw with a liberty to refile.
The reasons.
Fantastic.
No, I have not received. That is the point, Your
So
Lordship.
therefore, now you having received, you like to challenge it.
Lord.
Come up with that.
No, if Lordship permit me,
Yes.
if notice, what I have gathered now, if Lordship may issue a notice, in the meantime, I also stand my clarification. If it is okay, then I will withdraw my case. At least if my, what my client said, at least I can got an opportunity from this honorable court. What the stand has been done by these orders.
Okay, we'll issue notice.
Lord.
But there is no stay.
No stop.
Issue notice making it returnable on 9th of February 2026. Mr. H. Gupta appears on behalf of the respondent numbers 1, 2, 3, and 4. As regards the respondent number 5, the extra copies of the writ petition be furnished upon him by tomorrow.
Lord.
As regards the respondent number 5, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, liberty is given to the petitioner to effect service upon the respondent number 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the disqualification of the petitioner.
Lord.
And no opportunity granted to the petitioner to submit the shortfall notice full stop. The facts of the instant case as it appears from the materials on record is that a notice inviting tender was issued in the GEM portal by the respondent authorities for collection and disposal of waste management service, that's lifting, transportation, unloading, semicolon, dry waste for a contract for a period of 3 years. It is the case of the petitioner that the petitioner have duly submitted all the documents at the time of submission of the bid. The counsel appearing on behalf of the petitioner, Dr. B. N. Gogoi, further submits that altogether 9 bidders had submitted the bid. However, the respondent authorities disqualified all other bidders except the respondent number 5, who quoted an amount of rupees 57,48,750. The learned counsel further submits that the illegality of the respondents is not limited to that, but also to the fact that the contract has been awarded in favor of the respondent number 5 at a total consideration of rupees
Page 72, Your Lordship. 812760.
81,27,630.
Lord.
which is beyond what was quoted by the respondent number 5. He therefore submitted this is a fit case for interference, taking into account that it is a rampant case of favoritism in order to select the respondent number 5. Per contra, Mr. H. Gupta, the learned counsel appearing on behalf of the respondent authority, submitted that the petitioner did not comply in terms with clause 1.2 of the additional terms and conditions of the contract, which mandated the submission of a CA audited balance sheet as well as a certificate issued by the certificate pertaining to CA certified banking reference. The learned counsel appearing on behalf of the respondents further submitted that this aspect was very much notified in the e-portal. However, the respondent authorities, however, the petitioner even did not choose to challenge the same or fulfill the requirement within the permitted window of 2 days. And as such, the petitioner can now not challenge the same. Taking into account the above, it is the opinion of this court that the said submissions were made by the learned counsel appearing on behalf of the petitioner be brought on record by way of filing an affidavit. The learned counsel appearing on behalf of the petitioner also sought for an interim direction pending disposal, pending the next date. Taking into account the stand which have been submitted, the submissions so made by the respondent, this court is of the opinion that an opportunity has to be granted to the respondent prior to issuing of any interim directions. Inasmuch as if the petitioner was technically disqualified for non-submission of a particular document, it is the prima facie view of this court that the petitioner cannot raise any objection in pursuance as regards the selection of the eligible bidder. Under such circumstances, it is therefore the opinion of this. In addition to that, the respondent number 5 have already been issued the work order. Considering the above, this court is not inclined to pass any interim directions today, which shall be considered on the next date. In addition to that, this court further observes that not passing of an interim direction today shall not create any equitable interest in favor of the respondent number 5. And the contract so granted in favor of the respondent number 5 would be subject to the outcome of the petition. Yes, Mr. Goswami? Yes.
65, 66, that NRL blacklisting case, there has been some development. They have changed the empanelment, so I think the NRL
Affidavit has been filed yesterday, my lord.
Which one?
An additional affidavit has been filed by the petitioner yesterday, my lord. I need to seek some clarifications on that, my lord.
It may be necessary.
65?
65 and 66. The supplementary list.
Okay. We'll take care of it. You be there. You need not be
I
there.
live-
We'll record your presence. She will be there. No?
Yes, yes.
Timing item 4 and similar items 62 to 64.
Yes, what is your case? Tell me.
Yes. Lord, the petitioner before your lordship is a registered partnership firm engaged in similar line of business of dismantling for several years. Lord, the petitioner has admittedly not participated in the instant tender process. Two grounds of challenge taken in the writ petition on the tender process, Lord. The first is inadequate publication of the tender, and that links to the participation of the petitioner as it is on affidavits that the petitioner did not know about the tender having been floated on the MSTC portal, although the petitioner happens to be a registered entity on the MSTC portal. So in usual course of business, the petitioner is there on MSTC because there are several tenders floated on the MSTC portal. But my lord, the regular course, my lord, the tenders which are of high value like the present tender, my lord, are generally also floated in other government portals, websites and elsewhere, my lord. This is one of those tenders where no paper publication, at least the petitioner could find, or any other publication on any other similar portals was found. Hence, the petitioner did not know, did not participate. Now, my lord, when the petitioner got to learn about this particular tender, the petitioner obtained the e-auction catalog, and from the catalog, the second round of challenge of the petitioner is that the pre-eligibility criteria for participating in the tender seems too tailor-made, my lord, if that coinage of the word may be used, my lord, because, my lord, there are certain eligibility criteria which have no rationale to the work that has been offered to be tendered by the state authorities or by AIDC in the present case. My lord, if your lordship on these two grounds, my lord, first on the publication, my lord, the publication point of inadequacy or adequacy of publication stems straight away from the Constitution, my lord, Article 14 and 21, my lord, wherein it has already been, my lord, several Supreme Court judgments, my lord, have stated that right of opportunity of a person who wants to make a bid for any government auction is enshrined under Article 21. My lord, from that, my lord, also in the Assam, in the state of Assam, my lord, there are one particular act, my lord, and the rules framed thereunder, my lord, which in respectful submission, my lord, may have some manner of application to the instant tender process, my lord. I am, my lord, referring to the Assam Procurement Act of 2017, read with the rules of 2020, my lord, which also provides for publication of tenders and how and in what manner it should be done. My lord, although the act and the phraseology of the act which reads procurement suggests it's for procurement works, but my lord, the definition, if I may, before your lordship, show the clauses of the Procurement Act, my lord, it's very wide, and it would even concern this particular tender, which is in the nature of dismantling and completion and picking up the scrap material from the kachar paper. Demolition and lifting of the scrap, my lord. If your lordship, my lord, takes the act once, my lord, I'm sorry, my lord, before the act, if your lordship takes page 23 of my writ petition, my lord, once. Lord, page 23, once, if your lordship takes, my lord, this is a part of the e-auction catalog. Auction of plant and machinery, demolition, disposal, and clearing to ground level of all buildings and other civil structures in plant and machinery area, along with disposal of fixed assets inside the buildings of Kachar Paper Mill, Panchgram, district such and such. My lord, this involves three works, my lord: demolition and bringing to ground. My lord, now in this slide, my lord, if your lordship takes the act, the Procurement Act, my lord, first. My lord, the definition clauses define the act.
Where is the tender?
Yes, my lord.
Where is the tender?
My lord, the tender is annexed with my writ petition starting from page 23. But 23 is the relevant page. The first page of the tender is 15, my lord. 15 onwards, I've annexed the e-auction catalog.
Does the tender refer to the Assam Procurement Act?
No, my lord, the tender doesn't.
Is it the duty of the state, of the respondents to, is it mandatory on their part to go for a e-tender, for following the mandate of the Assam Procurement Act?
No, to that, my lord, may I just show the act once? If the act governs procurement works by the state government or any entities under the state government, if the entity which is now floating the tender falls within the definition, my lord, perhaps the act automatically assumes relevance to this tender, which is
Because,
also.
Mr. Counsel, otherwise it is not, no end. There is no end to it. You knew it very well. You have not taken normally when it is done to the MSTC, you say, as per the Assam procurement here, either it can be done under the GEM portal or under the Assam tenders.
Yes.
This is the manner in which it is. So therefore, if it is done through the MSTC, the entire tender has to go altogether if we go apply the Assam Procurement Act.
No,
Yes.
Assam Procurement Act perhaps, my lord, also consider the rules, considers procurement through agency. Procurement through agency, it also says that even if it is either directly or through an agency, you still have to do the publication in a certain manner, if the act applies. If the act would not apply, my lord, then nothing applies, neither the rules nor the act. My lord, so when it mentions agency or direct,
When was this notice inviting tender issued?
my lord, 7th August 2025.
And when did you come to learn?
My lord, if your lordship takes my writ petition.
And how did you come to learn?
I came to learn from other market players, my lord, after writs were already filed before this honorable court. I came to learn from other market players, my lord, this is a scrap dealing and demolition work, my lord. There are,
Yeah, you are a fence-sitter.
yes, my lord, I absolutely, my lord, to that, my lord, this is. a
Division
question.
bench.
My lord,
This is for division bench to look, consider,
my lord, may I just,
isn't it? Fence-sitter?
There is a fatal delay here. It was
He's a
issued
pen-
in the
he's a
month of
fence-sitter.
August, and then they have filed it in the month of November. They were sleeping for 3 long months.
Fence-sitter.
By that time, lot of developments has
You are
taken
trying
place.
to take the benefit of an order passed in another writ petition.
my lord, may I just try to, my lord, before your.
What are your
lordship-
credentials? What are your credentials that you have been all along participating in various bidders?
Yes,
Where is it?
my lord,
Not a single document has been enclosed.
if your lordship takes paragraph 1, my lord, the documents along with this, my lord, we have not annexed the documents, my lord.
Then,
My lord, there is a point on affidavit, my lord, at paragraph 1.
Hmm.
If your lordship permits me, my lord, for the documents, my lord, I'll come back with the documents, my lord. That part I cannot run
Okay.
away. It's on affidavit. I have
hello,
to
we have it.
substantiate.
How much? 6 months?
My lord,
By the time it will be over, no?
my lord, I understand this is.
By 6 months, your dismantling will be over?
I do not have the exact instructions. It is a big project. It's just like this Jagirot paper mill. So it may take little bit more also.
Then also, if he has the luck by 6 months, if he can catch the wind, have the wind. Don't have, no case. Bad case,
My
fence-sitter.
lord, may I just, on one point, my lord, may I try to satisfy your lordship, my lord?
Then, Mr. Counsel, the problem is, we allow your one, or ask you to come within the ambit of another pending litigation. Where is the end?
Right, absolutely.
Everybody will come up and say that another person, Mr. So-and-so, had also filed a writ petition. He also told me, I would have also participated.
My lord, may I
That
just-
is your
may I-
excuse.
my lord, it's not, it's something that, my lord, on facts I cannot run away from, my lord. My lord, may I just try to satisfy the conscience of the court to one extent, my lord. My lord, if there exists any anomaly with respect to any tender floated, which, my lord, has not been finalized till date, my lord, and I being one of the persons who, my lord, try to say or have said in my writ petition that I would have.
We do one thing.
participated.
We do one thing very well. Then if that be so, we adjourned on the basis that you have not filed any document.
My lord, that is.
So no notice is be issued. In the meantime, I vacate the interim order. It will be finalized. Matter over then.
That document.
My case is,
No
he
case.
is a part of that MSTC portal.
Yes, yes.
And he failed to look
Well,
at for his ignorance and
is
his
it done in MSCT
negligence.
portal? Is it required as per the MSCT portal? Or any auction is held through the MSCT portal that there is a publication on paper?
No.
Then matter ends.
But my lord, if MSTC portal, my lord, perhaps the rules of the MSTC portal would not circumvent the rules framed by the government, my lord, for procurement, if the act applies. My lord,
So
an
then
MSTC
the entire tender process will go.
Yes, that is my
So
challenge.
therefore, your case has to be that the entire tender process will go.
Yes, my lord, I have challenged the tender. I have not asked for participation. My lord, my first challenge is to the process. For the simplicity reason, my lord, that if it is violative of any of the acts or under the constitution, if the publication was required, if it was. But that is what I'm trying to urge before your lordship, my lord. If your lordship finds that publication is not adequate, my lord, then opportunity under Article 21, my lord, may now, my lord, as the facts of my case, I have been a fence sitter. I have also not participated in the tender. And my plea is that, my lord, I couldn't even have participated or challenged the terms. For, my lord, not being aware of it at that point in time. My lord, to that extent, if your lordship is of the view, my lord, that the act or the rules apply and there has been an anomaly in making publications under those provisions of the act or the rules, my lord, then your lordship perhaps can look into the process.
No, you have to come up very clearly that under no circumstances, when if they go for an MSTC also, they have to follow the act.
Yes, my lord, if your lordship takes the rules once, my lord, if your lordship takes the rules once,
Yes.
first, my lord, may I show the act once? Because if the act applies.
Mr. Counsel, what is wrong with you?
My
You
lord,
have, when the moment you say that you should try to show me the act,
I-
then I take up the act,
Lord-
then you go to the page 23. Then after I take up the page 23, now you say the rules. When I take up the rules, you say again come to the
my
act.
lord, I apologize. My
What do you want?
lord, kindly
Be
takes the-
clear with your
kindly-
case.
Kindly takes the rules. Kindly takes the.
Which rule?
My lord, the Assam.
What
procurement
rules? Rule number?
My lord, rule number 21.
Yes.
Registration, my lord, 21, contents of bidding documents, my lord. If your lordship comes straight away to, my lord, Roman 5, notice inviting bids, my lord. The lengthiest.
Yes.
A procuring entity shall invite bids in open competitive bidding and two-stage bidding or pre-qualification or registration of bidders by issuing a notice inviting bids to be published in the state public procurement portal in case of open competitive bidding and two-stage bidding with value below the mandatory e-procurement threshold. If the NIV is not published on the SPPP, an abridged notice shall be published in newspapers of wide and adequate circulation wherein the address where details and bidding documents shall be made available must be mentioned. My lord, now if your lordship comes to C, the notice inviting bid shall simultaneously be published in an abridged form in at least two newspapers, one each in vernacular and English of sufficiently wide circulation for ensuring maximum competition and indicating therein at least the type and subject matter of procurement in brief, the date and time for submission of bids, and the addresses of the website, etc.
So therefore, I have that question to you before seeing that. So therefore, it has to be either published in the GEM portal or in the Assam tenders. But if it is done under MSTC, how do you bring in this rule?
But kindly give me one moment, Lord. Just give me 1 moment.
Last time on 14/11, when the matter came, I gave you the time to prepare. Today, after 1 month also, you're not prepared. Getting a notice, forget about an interim order, getting a notice is very difficult.
No, Lord.
Yes. But Mr. Counsel, don't you think that you should have placed before this court certain credentials?
But that.
Just one paragraph you have mentioned out there. There is no credentials that you are habitual. You have been doing. You have been purchasing such and such things and all. And in the MSTC, if you are doing it in the MSTC portal, you therefore, if it is a MSTC portal, there is publication also when it is done by the other states. It is being done. Something is to that effect. Nothing is there. You have been. Have you been? If you are a regular bidder in the MSTC portal, obviously you don't look into the newspapers for that. You see it out there. And it is not this court is not for the first time looking into an MSTC portal. The MSTC portal, all scrap materials are through MSTC portal only. And it is only published in their website. Then you know it very well. You wait out there and then taking into account that there is another matter going on, now you come up before this court. That case, we dismiss. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. You appearing, Mr. Sekia?
AIDC. Just 1 second, Lord.
Mr. So-and-so.
One, respondent number 1.
Appears for the respondent number 1. Where is the union? Any person from the union? R.K. Dev Chaudhary nominally appears. Hey, yes, you are there. Yes, you appear. Yeah. So-and-so appears for the respondent number 2. The petitioner herein have assailed the auction, the tender process corresponding to auction number MSTC/GHY/ Assam Industrial Development Corporation Limited /5/Guwahati/2025-26/25321 in context with the detailed auction catalog dated 7/8/2025. And other consequential reliefs. The basic ground on which the petitioner has approached this court are twofold. First, that there is no adequate publication as is required under the Assam Public Procurement Act 2017 and the rules framed therein under. It is the case of the petitioner herein that irrespective of the publication of the notice in the MSTC portal, there was also a requirement of publication in 2 newspapers, of which one is vernacular and the other is in an English daily. This having not been done, the petitioner have therefore challenged the entire tender process. The second ground on which the petitioner assails is that the tender has been made in such a manner, the tender conditions are framed up in such a manner that these are just tailor-made to suit some of the bidders. It is under such circumstances the petitioner has therefore approached this court. First, it is seen from the materials on record that the notice inviting tender was issued in the MSTC portal on 7/8/2025. Where have you mentioned that you are registered? In the MSTC portal? Not a single statement. There's not a single averment that the petitioner is enrolled in the ASTC portal, MSTC portal. Though the petitioner avers at paragraph number 1 of the writ petition that the petitioner firm is engaged in the business of dismantling, demolishing, and demolition and disposal of old and obsolete factories, plants, machinery, ships, and industrial structures for more than 5 decades. It is pertinent herein to take note of that there are no credentials in that regard have also been mentioned in the writ petition. This court further takes note of that there is no, though the tender was issued in the MSTC portal dated 7/8/2025, the petitioner have also not disclosed as to how the petitioner had come to learn about the said tender. Only at paragraph number 7, it is being mentioned that the petitioner on inquiry came to learn about the e-auction. Paragraph number 6, the petitioner has mentioned that the petitioner had come to learn from recent interactions with some other industry competitors. There is no date also mentioned when the petitioner obtained the catalog. And what steps the petitioner took except submitting a representation on 30/10/2025. To the various authorities. From the above aspect, it therefore appears that the petitioner was a fence sitter. Be that as it may, this court further finds it relevant to take note of the submissions made by the learned counsel appearing on behalf of the petitioner as regards the applicability of the Assam Public Procurement Act 2017 and the rules framed therein under. In that regard, reference has been made to Rule 23, 21, Roman 5, normal 5, Roman 5 of the rules of 2020 and submits that it is the requirement in terms with Rule 21(5) Roman 5 bracket C that the notice inviting tender shall be simultaneously be published in an abridged form in at least 2 newspapers of which one is in vernacular and the other is in English. In the opinion of this court, that the said submission does not merit, taking into account that a reading of Rule 21 bracket 5 Roman 5A refers to open competitive bidding for which there is a requirement of issuance of a notice inviting tender to be published in the State Public Procurement Portal. The respondent number 2, under no circumstances can be said to be the State Public Procurement Portal. Is it? It is not the state's public.
No.
For that you have GEM as well as the Assam tenders.
There are two.
Under such circumstances, it is the opinion of this court that Rule 21 bracket 5, brackets Roman 5, brackets C, small c, of the rules of 2020 is not applicable. Nothing further could be shown as that further could be shown that when notice is published in the MSTC portal, there is a requirement of publication in newspaper. Considering the above, it is therefore the opinion of this court that the petitioner is a fence-sitter. And there being a publication in a recognized mode, that is through the respondent number 2's portal, it is therefore the opinion of this court that the said publication cannot be said that it cannot be that the tender notice cannot be said to be in violation of inadequate publicity. First, taking into account the above, this court therefore would not like to enter into the second aspect, second contention, as to whether the tender conditions were tailor-made, in as much as the petitioner, having not participated, in as much as the petitioner is not entitled to question the tender process, as the petitioner is a fence-sitter. In view of the above, this court is of the opinion that this is not a fit case for issuance of notice or even entertaining the writ petition under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed. We are done with this. Now come to the other.
Item 62, Your Lordship.
Yes.
Please, Your Lordship. Lordship, pursuant to Your Lordship's liberty, we have filed an implement application. Bring for implement of all the technically qualified bidders. Four zero one four, Your Lordship.
Were you making the technically qualified, not the others?
Lordship,
You have the names of the rest of the 20.
yes, Your Lordship, the difficulty,
We have no problem with these 3. We have the problem with the others who have been affected because of that order.
right, Your Lordship. Your Lordship, order was if so advised. Problem we face is that the scope of my writ petition is rejection of my.
We do one thing. We implead them and dismiss your petition on this ground, non-impleadment of other parties.
If Your Lordship then comes to a finding that they're necessary parties,
Why should I? I gave you the scope.
no, Lordship.
You did not.
let-
No, you
no,
did
let me
not.
explain.
No, you did not. I gave you an opportunity that day, asking you that if so advised. Your advice is not, in my opinion, it is necessary. So we therefore, because the reason why the others were required to be made a party is in view of the order passed by the learned coordinate bench, thereby allowing you to participate in spite of holding that you were technically incompetent.
No,
Yes.
Lordship didn't, that is the subject matter of my writ petition. There's
No,
final decision
it
on
was categorically held that you had that decision so taken to hold you to be technically incompetent was right. That is the observations made by the learned single judge. Yes, it categorically says that. After that, Kindly come to this paragraph.
Yes, yes, Lordship.
Thus, considering the fact of kindly see, the materials brought on record, admittedly, the petitioner herein along with the bid had not uploaded the valid OS certificate, and accordingly, the rejection of the bid of the petitioner by the respondents by the email was proper.
Correct.
So if once it is being held to be proper, therefore, the opportunity which was given to you to participate has to be also, in order to, this court cannot commit a mistake. So the mistake if it was committed thereby, qua the other tenderers who could not participate in view of having that particular document or having not approached this court, they are to be heard.
Lordship, the problem is that my writ petition does not prejudice them. What prejudices them is the act of AIDC. That is my problem. So I have to expand the scope of my writ petition. Your Lordship can, I cannot. My scope is I am technically wrongly disqualified. That is the scope
So
of my.
therefore, I expanded it by putting that question in the last order. A question duly arises as to whether the sanctity attached to the minutes of the meeting dated so-and-so survive within the ambit of Article 14 of the Constitution, when out of the 20 bidders, only 3 bidders were held to be technically qualified. And this court by an order only permitted 1 bidder to the exclusion of others who were similarly situated. So I extended the scope.
Lordship,
Now, in that basis, I asked them to give the details of all, both the you see the line is, A. Kakoti, the learned standing counsel appearing on behalf of the shall provide the addresses of both the qualified and the disqualified bidders to Mr. R.J. Das, the learned counsel so-and-so. Liberty given to the petitioner to include other bidders if so advised.
Yes,
So why should I advise or take the role of an advisory jurisdiction?
we decided on the basis of the scope of my writ petition.
Huh?
If I have to expand it, then it has to be.
Now, therefore, it is.
Lordship may hear me. It will be on the basis of a finding that AITC has flawed in rejecting everybody else. Now, I cannot be somebody else's advocate. I can only be an advocate for my own thing. So my scope is I was wrongly rejected. I don't think even the technically qualified bidders are actually necessary parties. But they are proper because they are the only ones who are affected by me entering the race.
Technically qualified bidders were necessary parties that is already there as per paragraph 22 of FCONS. There's no quarrel with that proposition. The law is settled in on that aspect.
Lordship, we are not aware of who they were, so we did not. So we have now. But the point is now to then get into an inquiry of who is similarly situated, we are incapacitated. The only person.
Absolutely not. Taking into account that the tender, technical tender disqualification document has been enclosed to the writ petition affidavit. Why you are making that submission? It is there. Kindly see. No. It is there in the minutes at page 130, 28 onwards.
The problem is the list. We're not clear who's only on our ground and who's not. There is.
Kindly see number 7. Disqualified as OS certificate and self-attested so and so. Yes. So OS certificate is not there.
Lordship, there are twin conditions.
Yes.
There are twin conditions.
Kindly see Kantar Steel India Limited disqualified due to unavailable OS certification. Kindly see this. You are already there. Why you are submitting that you are not there?
Lordship, then come to a finding that AIDC was wrongly rejected similarly situated. Come to the finding we'll have.
No.
Finding on that.
No, we therefore set aside the entire the tendering thing, the technical evaluation, and ask them to go for a fresh technical evaluation. Issuing horizon them, asking them to give more copies.
No, my submission will be different, Lordship. Those who were disqualified, apart from the other 4, the 16 remaining, they are not aggrieved. That's why they are not before the court also.
No, they are not agreed.
They may not be interested.
They may have taken it out there. You see, the problem arises because of that order. After holding,
It is
that
not our
they are
creation, Lord.
he is technically incompetent. The court permitted him, the petitioner out here, to participate.
I fully agree, and it is our opinion that the writ petitioner is not qualified on that day. And there is an observation also that our
Right.
reject him is proper.
Proper.
That opinion is
So
also there.
therefore, the court in exercise of the power permitted one bidder to participate. Now, just for example, let's take the court had taken the role of a tender inviting authority, which it apparently appears. Tomorrow, the tender inviting authority takes a thing, okay, we give up this OS certificate business, whoever is given. Are you therefore not required to give opportunity to all in that regard who doesn't have that certificate? And if you don't do it, wouldn't the court be the first one to strike your action? Now that is the issue. That is why that issue is.
Rationally thinking, Lordship, the more the merrier for AIDC. The previous case, there is a sentence in one of the paragraph that they stand with a bid of 120 crores, whereas our bid we received was 88. So there was have been a profit of.
That is absolutely
I
wrong
understand.
because of the
I
fact
wanted
that
him to
it is
place
a
his
question
case
of
in a much
bidding.
better way.
It is
Anyway,
a question of bidding.
yeah.
The question
But
doesn't arise.
if that kind of offers are coming and it is in the horizon, it is always better for us as a public organization, Lordship, to have the maximum value. We do not want to reject anybody on mere technical grounds, but we have to follow certain norms, which we have done.
You are right to do it. You are right to do it. But this court was wrong to allow it.
That I do not want to comment because we did not go to the division bench to challenge that order. Or neither any of the parties
No,
came
no,
before
you
this
see,
honorable court.
No,
in that
the
interim order.
thing is this, this court should have, on that day, disposed of the matter itself.
This is precisely, I said, that interim
Keeping
order
it
has the effect
pending-
of a final order.
And keeping it pending out here and say, making it subject to outcome in a bid of a particular of this time becomes very difficult.
So my humble submission that is that we do not want to go for a free tender, but we can take up from the auction stage, de novo, if Lordship allows the other to participate. But for that, Lordship, there should be consensus from all sides, or else they have to come before this honorable court and hear the matter on merit.
Ashok, that is also my problem. 5 came and withdrew. So they should have come. Anybody similarly situated should have come and should have made their case and gotten an order or not.
They came in with you.
But they came here and they withdrew. Out of 10 unsuccessful, 5 came, 6. No, 6.
There may be some
came and 5 withdrew.
pottery. I do not want to use that word syndicate.
That
No, no.
AIBC will know better than
No,
me.
I do not know. Because the more the merrier for us. We want maximum participation.
Argument. That is on the basis of which
But
actually I
you-
got
your-
the
yours-
order.
We have rightly rejected the other writ petitioner also. That is also one opinion of
No,
the.
one only worry is if I reject the petitioner, on the basis that the petitioner is not technically competent, and thereby uphold your submission, the person number 2, he will come up and say that this entire thing was wrong. So petitioner is out now, fresh
In
tender.
fact, that is why, let him come also, Lordship. Because
We beat them party. That is,
there is a difference of 1 CR only. So his offer is 88, the other party's offer is 87. But to 87, he was induced by his participation. It was auction,
that is auction and.
No,
price
yeah,
just like we do it in
No,
IPL.
Mr. Saikia, have you looked into that? How it is going on? Have a look at. how the
He
sheet-
told me that.
No, no.
It was going competition one by one.
One by one, it is going on.
Yes,
So
Lordship.
what was happening?
That Ram and Shyam's case original.
Yeah.
That is why you chose auction and
Yes.
not price bids. More
So
than merrier.
therefore, this is like this.
So that is why if anything is vitiated at the stage of auction, definitely Lordship will set aside that part because of the participation of a person who otherwise is not entitled, then we can redo the auction part. But not the whole issuance of tender process again.
No, not issuance of.
We do not want to go to the,
Tender process issuance doesn't arise. The thing is, one thing is that you may have to give up that OS certificate.
No, that certificate for 4 has submitted, Lordship. So there is nothing wrong in that.
3 have submitted. and I
He has
came in
submitted-
late- And I came in late and submitted.
They submitted, but their statement is that
You're right, we submitted.
they have submitted a wrong one, the invalid one, but they have a valid one from
Mr.
May,
Correct.
May 2025. The auction was in the month of August onwards.
Document.
So that document was in existence if it was not manufactured later on with a back date. I do not know. I don't want to make any comment on that. But normally, any prudent person would have uploaded the valid one.
And what is the case of the other writ petition?
Relax. More time for spinach.
Your case is that there is no such certificate.
My lord.
Your case is there is no such certificate. That matter is where?
Next item.
Okay, where is Mr. D Das? He's not there. Yes, what is your case?
This is, my lord, in fact, what happened, my lord, as per the terms and conditions, my lord, for technical bid, we participated. Then, my lord, on the, when the, my lord, the committee meeting was there. Meeting with the date, day, my lord, at around 9 PM, but we have been informed that you have been disqualified. For 10 technical bid, we have been disqualified. That was the observation. So, my lord, what happened?
What is your name?
MTC, my lord.
Huh?
MTC Business Private Limited, Sector 3, serial number 63, my lord. MTC, my lord,
MTC business.
yes, ma'am. MTC Business. Private.
Bank statement or undertaking from the seller regarding payment not submitted. Self-attested copies of the seller's safety terms and conditions as stated in the STC's document not submitted.
Yes, madam. But in fact, what happened, so far as the, my lord, the first requirement is concerned, my lord, in fact, that was not as per the terms and conditions of the NIT, number one. And subsequent one, it was on the, my lord, modified terms and condition, it was, my lord, included, modified terms and condition. Here is the case, what happened, my lord. My lord, it is not that, my lord, they don't have the power to modify the terms and condition requirement, whatever it may be, my lord. But they've substantially changed the, my lord, terms and conditions.
When?
My lord, it's like, my lord, they have not, my lord, properly notified. Of course, before the auction took place, my lord, it was notified, but it was, my lord, modified, but it not be properly informed. As per the requirement, my lord, the lordship may kindly see, my lord, how it was uploaded, my lord. They modified, which your lordship will find from the affidavit filed by them, my lord. From the affidavit only we come to know, or there is a modification, my lord. So modification, my lord, how it was affected, my lord. Lordship will kindly see, but it is properly done.
Where is this, madam, what is this OHSAS certificate? Where is it in your petition? In your writ petition? It is, how are anybody is saying it to be the OHSAS? OHSAS, how is anybody referring it? Where is H? OHS, and what is A for?
My lord, if your lordship permits me, my lord,
What does A for?
Assessment series, assessment series.
Huh? Because this is not, this can't be the certificate.
Occupational health and safety assessment series. Occupational health and safety assessment series, that is.
Assessment?
Assessment series. Series, SERIES.
CD.
Series.
Where is that? You have that certificate?
No, that is an obsolete provision as per the ISO standard 18,001.
So therefore, this provision is very much not there.
Okay.
You see, therefore I'm saying, kindly, this is very interesting. Kindly see, your mandate as per the tender condition is OHSAS certification. Whereas the petitioner herein says, Her certificate here, she had the certificate. Now kindly see, her certificate is at page 80 of the writ petition.
Edifice. Page 80.
80.
Yes, page 80, Lordship.
Occupational health safety management system. Where is the A?
আমার একটা requirement to কি আছিল? OH? Why A is not there?
Where's the A?
OS, SAS.
Huh? No. Then the problem is it couldn't have been. It should have been OHSMS.
That is correct. With effect on 2019. There's no dispute that this is the right.
No, there's no dispute, but you see, what was notified is in the tender condition is OHSAS. Now, as per that, there is no OHSAS. Now, understood. That is what is the case of Mr. Diganta Das' client also. And he's also who got his dismissal. Isn't it? Where's that counsel who got the dismissal just now? He's left. His case was also that. The second point, which I didn't go into.
And there was a request that the STC document published on 7/8 and bidders were allowed time till 3/9 to raise queries. Certain bidders requested acceptance of ISO 45001, which is here at page 80. In lieu of OHSAS, AIDC considered to their request, allowing ISO 4001 as an acceptance alternative.
No,
So we
then
have
this,
accepted-
then this has to be issued as a corrigendum.
It was, my instruction is, it was modified in the terms and conditions in the portal itself.
No, portal it was not given, na. That is what it is. You see, this is the tender document, na.
Right. This request was come during the.
Where is the
interaction.
tender document where you require the OHSAS? Because they initially changed it. Page? Yeah. You see here, kindly see page 44. This is interesting. Safety qualification criteria for bidders must have OHSAS certification. Now kindly see there's a small 4 on top.
Yes.
Now kindly see 4 earlier. It was OHHAS corrected to OHSAS. This was done on after that. 25/8/2025.
Yes.
So nobody has OHSAS.
That is okay, that there is no difficulty on that. But in lieu of this, another certificate was allowed. That is ISO 40001.
What was the last date for submission of the bid?
It was in September. 9/9 was the last date. All these were allowed during the query.
Huh? Where is the document where it was permitted? Page 80.
Inspection schedule. And the last date is 10/10. And then upload, closing in 15/9. Sorry, your lordship, 15/9.
This is 15/9. And when the corrigendum was issued? The 25/8 is OHSAS.
Only that change. But there was more changes also.
Where is that? Because that
what
is the
I'm asking, that in that portal, there is no scope for adding any documents. So they change the content by modification.
No, then in that regard, can anybody else know it?
My instructions now is that they have to keep updating themselves with the portal.
That cannot be the right.
That is little bit irrational. I do agree.
It is the case, our case, it is the case, my lord, it has not been formed.
So let me take the complete instruction, how this whole thing progress.
I think this is to be set aside then, I think. We set aside, go for a fresh one by issuing a corrigendum properly. Having the same terms and condition, issue a fresh corrigendum and have the same tender.
Let me take the instructions, Lords. It may not prejudge us. If everything is in order, because today the case is not for hearing. And I was just
You
last
only
night,
you wanted the matter tomorrow.
on Friday.
Not.
I wanted on Friday.
We'll have it on Monday, wait.
No, Monday, little bit difficult, Lordship. I will not here.
Monday,
Then
I am not there, so I am having it on Monday.
if it is on Monday, then they will have to change the council. No problem for that also.
Then in that
On
regard-
Friday, let it be taken up.
Huh?
Let it be taken up on Friday if it is not.
Friday not possible. Friday we have a reference at 3:30. So not possible. Justice Gyan is dead. So not possible Friday.
May I say something? So for our case is concerned.
I do not want this matter be taken up in a very fast manner so that it will go to the division bench. I want everything to be settled with all the pleadings.
Where is that other side council? That council I dismissed his petition.
Later on, they will come
You are
and say
there,
that they were not given enough time to give a counter.
Now taking into account this view, let me issue a notice in his case. Instead of dismissing it, keeping the point of pen-sitter open. Because otherwise there will be certain of it, because taking into account he has that point also.
No, Lordship, I do not know. The instruction is also not proper.
Because
It has-
his point, what he has taken the second point.
He
Let
he
him
has
not,
not acted at
actually,
all.
Mr. Counsel, you made the wrong argument. You should not take. You should have taken the argument only on tailor-made. On the basis that, look here, taking into account what is mentioned out there, I could not. But you made
His
the
case
wrong.
is that he did not participate. All rest all are
No,
participants.
that case, his case is also he did not participate. But he never said that. He said, I knew it. But I did not participate because I don't have the OH SAS certificate.
That is like that airport authorities case of 1979. That
So his submission is that.
yes,
That
but
look here, I knew
but
it.
the previous case which was dismissed by
he-
Lordship,
his
he
case
said
is
I
different.
was not aware of the whole tender process.
So therefore
his
it is,
case cannot be equated with the others.
it is not equitable. But as we are going to do it, why should his writ petition be dismissed?
Let him be in the comfort zone. Let the notice be issued. I do not think.
Let him be there
I
in the
said
comfort.
because I'm very happy that he offered a bid value of 120 crores. So that is attracting us.
Chalo.
If
think
by
then-
any way they can come in, we'll be more than happy. But he will have to stick to that.
But the problem is,
Or the rest will increase our base price to 120. Then that will be the base price.
I have it. Better. Then if you don't get anybody, then you catch hold of him.
No, on oath he have committed 120.
No.
Site visit, my lord, we quoted 111 crore. 111 crore without site visit, my lord. We quoted.
So we'll allow them to go for a site visit also.
Yes, it can increase also.
Let the indigo problem be over. You go for a site visit.
So it's my lord, so for our case is concerned, my lord, we file a IA also, my lord, to bring amendment, because my lord, certain issues are there, which are not properly notified. It was not by way of corrigendum or addendum, my lord, so that because it was not came to our notice. So we file abundant precaution, my lord, we file IA, my lord, to amend the petition. Or lord, kindly have a look, my lord, see, my lord, it is again.
Hey, are we on writ petition আছে নহয়? কোনখন আছে? Your matter is where? Another case is there, na? Edifice, MPC and another one. Where is your case? It's not listed today. Item number 4 likhibo, huh? Issue notice. When do you want it? You want to file your reply?
January, Lordship, first
Huh?
week of January.
No, first week not possible. You later on you will take time.
There are a lot of holidays are there. That's why I'm saying first week.
Chalo.
Let it be on first week, then final disposal after in the last week. Maybe there are huge, very long holiday in between. I just scrolled the calendar yesterday.
We are working from 20 the December
28th, I think.
20 December to 18th January. High Court is only working for 5 days.
Yes.
Yes.
So in fact, more than the holidays we get in October now. Nowadays, observing in January there are more holidays.
So next year, therefore, we have reduced it from 23rd, 24th. We are having the vacation starting. Anyways, we issue notice making it returnable on 7th.
Lordship.
7th 1/2026. E2 petition, the number 4. Mr. D. Dekar, the Learned Standing Counsel of the respondent number 1 accepts notice. Mr. D. Dekar's Learned Standing Counsel appearing on behalf of the respondent number 1 and Mr. So-and-so, the Learned Counsel appearing on Learned CGC appears on behalf of the respondent number 2 and accepts notice. As the respondent number 1 and 2 are duly represented by their respective counsel, extra copies of their petition be served upon them during the course of the day. First, the petitioner has approached this court challenging the tender process as well as the conditions of the tender to be unreasonable and violative of Article 14 of the Constitution on the ground of inadequate publicity, as well as on the ground that the tender condition has been made in such a manner, has been also framed in a tailor-made manner, tailor-made way in order to benefit certain tender bidders. Mr. D. Soike, the Learned Senior Counsel, appearing on behalf of the respondent number 1, submits that this is a case where the petitioner is a fence-sitter, and as such, the instant writ petition ought to be not entertained at all.
There is always a delay.
A fence-sitter.
My submission, Lordship, is according. That's why.
Further to that, the petitioner have also approached this court much after the tender process have already been initiated and no explanation have also been provided. The respondents are directed to bring on record their stand by filing their affidavits. This court, though, has issued notice, but the maintainability of the petition is kept open as regards the conduct of the petitioner and also on the aspect of delay in laches. So that is done. Now you have filed an IA. You want to implead, na?
May I make one submission, Lord, in item 4? Lord, may I also be permitted to file an additional affidavit to satisfy your lordships on the credentials, my lord? Because your lordship is keeping it on another day.
There's a liberty given to the petitioner to file additional affidavit, additional pleading, if so advised, on or before 19th of December 2025. Next week.
Yes.
Yes.
Otherwise, they will be prejudiced to file the reply.
Yes.
My lord, in 6417, we file IA for amendment of the petition.
Amendment, where is that? I or 3967. Now, what do you want implement?
In fact, my lord, that it was not proper by way of.
You want to insert paragraph 21A2, 21I. Have they filed any reply in your petition?
Yes, my lord.
They have filed the affidavit.
They file affidavit, we file reply also, my lord, but only, my lord, for abundant person, my lord, we want to bring on the record, my lord, that the amendment, my lord, which is in fact like not in accordance with the law.
Okay.
General financial rules, my lord.
They have filed a reply.
Yes, my lord.
So we have, my lord, incorporated reply, but my lord, for accounting purpose, my lord.
Hello, we allow with a cost of 10,000. Cost of 10,000, amendment allowing it, they have to again file reply.
The amendment, my lord, the cost, this would, my lord.
In the auction, we will reduce
Yes,
10,000.
my lord.
No problem, Lord.
No, cost has to be given, amendment allowing. No, where the cost?
Lordship will continue because.
He is worried for 10,000 when his offer is.
Dr. Todi, don't come up with all this.
Sir, if it-
No.
and they want to know that, my lord,
You see, I am a traditional civil court lawyer. I was a lawyer and now I am a judge also. At me, amendment has to be allowed with a cost
But
of
lordship will
10,000
kindly appreciate one
minimum.
thing, my lord. Only one thing, my lordship will appreciate, my lord. What happened, my lord?
Okay, we reject the amendment. Chalo. Heard Miss Dr. A. Todi, BP Todi, the learned counsel appearing on behalf of the applicant, and Mr. D. Sakia, the learned senior counsel, assisted by so-and-so who represents the opposite party number 1 and 2. Mr. So-and-so appears on behalf of the opposite party number 3. Allow 10,000 or dismiss?
In fact, my lord, it is only after filing by the affidavit, they will come to know that, my lord, they did it, my lord, highlighting the law.
The learned counsel appearing on behalf of the applicant submits that these amendments which have been sought for by way of the present writ petition by the present application are necessary for adjudication of the real issues in controversy. Per contra, Mr. D. Soikia, the learned senior counsel, submitted that these aspects were very much to the knowledge of the petitioner at the applicant at that point of time. And under such circumstances, this, if allowing of such amendment, this such amendment should not be, ought not to be allowed. Now also chance.
My lord, you are not, my lord, only after, lordship will kindly come to.
Now tell me, chance.
My lord,
Last
it's a
chance.
lordship.
10,000 or division bench.
Lordship
It will be
discussion,
more
my lord.
expensive.
Or division bench. Or division bench.
We have still in the, our,
Chalo.
I am, my lord. We say
Taking
lordship
into
discussion, my
account that these aspects, this court have duly taken note of paragraph 5 of the application profile. Paragraph 5 of the application, wherein the suggested amendments have been proposed, wherein the amendments, suggested amendment, proposed amendments have been mentioned. From a perusal of the said, it is seen that the respondent, the petitioner, the applicant could have very well raised these objections at the time when the writ petition was filed. It is further seen that after filing of the writ petition, whereby after filing of the opposite party, affidavit in opposition, now further changes are sought to be made to the writ petition, which would unnecessarily delay in the disposal of the writ petition. Considering the above, this court is therefore do not find any due diligence on the part of the applicant for which the application for seeking amendment is rejected. Okay, now
My lord, in fact, my lord, lordship will kindly.
25,000 now cost. Order
We have
passed.
stated in our, in the IAM, my lord.
Rejected.
Filing their affidavit will come to know there was an amendment, my lord, modification. Only after that, my lord, before that, we didn't know that. my lord.
Division bench will help you. Go.
And my lord,
Yours, you want?
4014.
IAC number 4. We rejected you.
My lord, then my lord, the interim passed earlier, my lord, by virtue of this order at 2111. It's my lord to be extended, my lord. It is only till next day.
Interim is there in their case also. I'm not asking not to give it. I know.
IS 4014.
This is an application filed for implement of the other technical bidders, technically qualified bidders by the respondent, the technically qualified bidders to the accompanying writ petition. Who have been impleaded as the opposite party numbers as respondent number 5, 6, and 7 to the accompanying writ petition. Taking into account the order so passed by this court, dated so and so, I got order to, passed by this court, dated so and so, dated 21/11/2025. It is, this court is of the opinion that the impleadment of the opposite parties numbers 1, 2, and 3 are necessary and essential for proper adjudication of WPC number of the issues involved in WPC number 5859/2025. Accordingly, the opposite parties numbers 1, 2, and 3 of the present application are arrayed as respondent numbers 5, 6, and 7 to the accompanying writ petition. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court by tomorrow. And the registry shall, on the basis thereof, make necessary correction in the cause title and also update in the CIS. I stands disposed. Main petition corner. Issue notice upon the newly impleaded respondent numbers 5, 6, and 7. Returnable on 7/1/2026. The petitioners are directed to effect service upon the respondent numbers 1, 5, 6, and 7 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioners should ensure that the service upon the respondent numbers 5, 6, and 7 are effected prior to 19/12/2025. Full stop. This court further extends the interim order passed till the next date. Yes, your case. Mr. D. Sekia, the learned senior counsel appearing on behalf of the AIDC submits that the respondent would like to file a reply affidavit in opposition in the matter. Considering the above, time is granted to the respondent number 1 to file the affidavit in opposition on or before 5/1/2026. List the matter on 7/1/2026.
Deeply obliged.
Last chance. Don't want it. Hello? No.
Obliged by for not imposing.
10,000 cost to the DLSA, to the High Court Lawyers Foundation. 10,000. Allow kori dibo. 10,000 cost, 25,000 cost.
Limited motion item 52.
Agor order to do question no. Amendment to allow kori. Allow kori that whole to file the amended petition by within by Friday.
My lord, this is second requisition, my lord.
Friday and copy to the other side, respondent to file their reply by 5/1/2026. Yes, what is this?
Second repetition, my lord, connected repetition, my lord, item number 69, my lord. My lord,
Hmm?
here, my lord, the petitioner challenged the work order, my lord. In the earlier repetition, my lord, the petitioner not challenged the work order because, my lord, the work order has not been uploaded in the portal, my lord. And my lord, during the, my lord, on 19/11, my lord, the respondent, when my lord, submit the work order, my lord, and my lord, petitioner came to know, my lord. My lord, even today itself, my lord, the work order has not been uploaded, my lord. The work order, my lord, page 1 to 3, my lord.
123.
Lordship.
There is notice to proceed with the work.
Yes.
Now what do you want?
Earlier occasion, my lord, petitioner challenged, my lord, the settling in favor of respondent number 5, my lord.
Hmm.
Respondent number 4, my lord.
where my lord, the petitioner not submitted, my lord, the income tax return in the year, my lord, 2024, 25, my lord. So, my lord, there is the extension of, my lord, the central notification, my lord. My lord, in fact, my lord, in work order, my lord, kindly see page 124, my lord. Till today, my lord, they respondent of it not uploaded, my lord, work order, my lord.
Now, what is this order? Another order passed?
Yes, Lord, your lordship passed, my lord, page 113, my lord.
That is for another person.
But still, it is.
Then what is this?
My lord, is the challenge, my lord, the earlier, my lord, the settlement of my lord in favor of respondent number 4, my lord.
Then?
And now, my lord, petitioner filling the work order, my lord, because my lord.
So this is in addition to that.
Yes,
It's a separate writ petition. That matter is pending.
good. Item number 69.
Okay, here we have to issue notice only. And we fix it along with. What happened on 10/12? 10/12, what happened? What happened on 10/12? Oh, tomorrow.
Today.
Today is 10/12.
Yes, 10 number 69.
10, where is that? Item number?
69.
69 today.
WBC number 6542.
Yes, have you filed your reply?
Yes, Lordship. We have filed it today.
In item 69, I scheduled some behalf of number 4. Beneficiary.
For?
Respondent number,
Private respondent.
private respondent number 4.
What is the name?
Dilip Kumar Parak.
Lordship, the affidavit is filed today itself, so maybe it is not in the record. So if I may.
What is your ground of rejection of the
Lordship,
technique?
Lordship, in item number 52, Lordship may kindly peruse page number 95.
52 of the
Lordship, it is the tender
new
evaluation.
writ petition.
Yes, Lordship,
New
the
writ.
new one. Yes, Lordship. Lordship may kindly
Page
peruse
52.
page 95.
Page 95.
This is the tender
Yes.
evaluation comparative statement. Lordship, the petitioner is the second one, Messrs. Zulumoni Rajkhoa. Lordship, here the reason is IT return and turnover not submitted for the last financial year 24 and 25. Lordship, here the case of the petitioner is that they are challenging that they have not submitted the IT return of the year 24 and 25. We have rejected only on that ground. But it is not true. We have also rejected that they have not submitted the turnover. Lordship may kindly peruse page 41. Lordship, here 4.3, clause 4.3, subclause 6. Lordship, may I read? Audited
Clause
report
6. Audited reports
on
on
the
the
financial
financial
standing of-
standing of the Iman such as profit and loss statement and auditors report for the last 5 years.
5 years. They have submitted only for 1 year, not for 5 years.
Where is that?
Lordship, in
Where- No, where
page
is the
number
reason
90
for that?
Lordship, this is the concise one. And we have received instructions that they have rejected on these two grounds. So they have
No,
not
no,
submitted
no,
the turnover.
no, kindly show me
Yes,
if
Lordship.
this administrative approval is for that amount of upgradation. Here you have taken into consideration, isn't this the document which is the basis on which you have cancelled the bid of the petitioner?
Yes, Lordship, there is two reason it is given here, and we have received our instructions that they have not submitted the turnover, that is the audited report, for
But
5 years.
no, but madam, my question is whether that was the subject matter of consideration at that point of time when the petitioner's bid was rejected.
Yes, Lordship, that was there because
Where is that document?
Lordship, in clause 4.3, the tender document,
I understand clause 4.3. There's no quarrel with clause 4.3 Roman 6 that he did not submit. But was that the reason for rejection in your
yes,
your
Lordship, it will
chart?
be there in the minutes. It will be there in the minutes. The reason for our rejection, it will be there in the
No,
minutes, Lordship.
whose document is this? Page 98,
95. This is our
95 or
document.
98?
Yes, Lordship.
Whose document?
This is our document.
So this is
the
what you have
uploaded
prepared.
document. This is only the uploaded document.
So if you have uploaded this, mean this is the reason which you have assigned.
Yes, Lordship, it is the reason. The turnover is the reason.
They have-
IT return and turnover not submitted by the last for the last financial year.
Yes, Lordship.
So
it
he
is-
has not submitted the turnover for the last financial year.
They are only saying that they have not submitted the IT return for 24-25, but we are saying that they have not submitted the turnover also for not only for 5 years, they are only submitted for 1 year.
Which
This
year?
is our challenge.
For which year did they submit?
Only for 1 year.
Which year?
Lordship, I have to call for the record.
So we grant a stay.
No, Lordship.
Yes,
Lordship, in the instructions
no,
also
no.
we have received.
we grant a stay.
Lordship may call for the record and
I'm not going to call for the records. You have to be clear.
Lordship, I have
I
received the
kept the
paraweight
matter
comment.
pending for the interim directions today. You cannot have
Lordship.
reasons more than that.
Lordship, actually, the thing is, we have received our parawise comments in that case and we have filed our affidavit in opposition. And the reason they have mentioned that they have
Madam, the law is very clear. If you have it, your reason may not be verbatim of what is mentioned in your affidavit. It may not be. But you have to have the edifice or the basis of the reason something. A seed has to be there for the purpose to make it a tree. Where is that? That is not there.
For that reason, we have mentioned the turnover part, Lordship.
So turnover only for 2024-25.
Lordship, they have concisely written it here.
You cannot concisely write anything else what is not
I
there.
understand, Lordship.
If that is
Lordship,
not the reason, then obviously this is to be rejected.
Lordship, the matter may be fixed tomorrow. We'll call for the record.
10,000 cost.
No, Lordship, we can't afford that.
Take a stay. We'll have it after vacation.
There is no anomaly. When he petitioner submits, regarding me, madam, I being the beneficiary, madam.
No. He doesn't have, but his rejection is, if he is rejected, his financial bid has not been taken into consideration.
I have already.
You are right. There's no fault of yours. That is not his challenging. What he is challenging is his rejection of the technical bid. The reason of the technical bid being rejected is not proper, taking into account the reason which is being assigned. And by way of a particular affidavit, you cannot enhance what is not there in the basis. Chalo.
Lordship, notice.
I have already comments for.
Oh, very well.
Lordship,
Don't
work
worry.
is
We'll
already-
stop it. I passed that order na, out there on the last occasion. Additional respondents shall not permitted to claim any equity on the basis that this court did not pass any interim direction today.
It's a pity for I will lose, well, I'll lose a lot of money.
Very well. Take it from them.
Lordship, the matter may be fixed tomorrow. I'll bring the record.
Tomorrow, why will the court will have the time for that?
Lordship, but on the instructions I have received, I have placed my affidavit in opposition. Lordship, I can say on that only and I can bring the record tomorrow.
Show me, by way of an affidavit in opposition, can you have better reasons than what is there in the records?
Lordship, that is there, but I am ready to bring the minutes. In that, they have taken the
You
decision.
have not brought the minutes. You should have enclosed the minutes. Why haven't you enclosed the minutes?
Lordship will bring. Because here it was written IT return and turnover, not submitted. This is the only,
Okay, 25,000 cost tomorrow.
Lordship, I'm just appearing on behalf of the standing council. I can't take.
So standing counsel is not here.
Chip.
Okay, none appears.
Lordship, I apologize. for
None
that.
appears on behalf of the respondent number 1, 2, and 3 when the matter is taken up. Mr.
Lordship, I
D. Gogoi
apologize for that.
appears on behalf of the respondent number 4. Full stop. This court, by the order dated 19/11/2025, have categorically mentioned, observed that the interim directions would be considered, have categorically observed that this court shall consider as to whether any interim directions are required to be passed today. Full stop. There is also no affidavit on record. Full stop. Mr. Ellen Dehy and the learned counsel appearing on behalf of the respondent petitioners drew the attention of this court to the writ petition being WPC number 7076/2025, which is also filed by the petitioner, challenging the work order issued in favor of the respondent number 4 herein. Full stop. From a perusal, the learned counsel for the petitioner further submitted that the perusal of the said reasons assigned is that the petitioner did not submit the IT return and turnover not submitted for the last financial year 2024-25. The learned counsel appearing on behalf of the petitioner submitted that the tender in question was issued on 23/5/2025, and the last date was for submission was on 28/7/2025. Under such circumstances, taking into account that the petitioner's return is not required to be filed till October 2026-25. The question of the petitioner submitting the IT return for the financial year 2024-25 did not arise. Further to that, as regards the turnover certificate, the learned counsel submitted that the said turnover certificate was duly submitted for the year 2024-25, isn't it?
23-24.
Huh?
It is 96, my lord.
Have duly submitted the turnover certificate for the 5 years from 2019-20 to 2023-24. Taking into account the above, and as the respondents have failed to produce any material, it is the opinion of this court that the petitioner herein is entitled to certain interim directions. Accordingly, this court therefore directs that till the next date, the work order which had been issued in favor of the respondent number 5 shall be kept in abeyance. List the matter on 9/1/2026.
Lordship, my name may be
Notice.
recorded. Lordship, my name may be recorded. My name may be recorded, Lordship.
No, you are not a counsel.
The order. One aspect I like to highlight, my ballot, the order to proceed with work was 1410. Petitioner approaches this court on 1911.
So what? They have not produced anything. I gave them the opportunity and help it.
SOPD, what we use? SOPD project manager.
And help it. Go to the division bench. They may help you. issue notice, issue notice. Returnable on 9/1/2026. You appear for response number 4 newly not in the new one. It will only get delayed because here also I am passing a step. Okay. None appears on behalf of the respondents.
Lordship, I apologize for that.
Who appears for Director of Technical Education? Mr. So-and-so accepts notice on behalf of the respondent number 6. As regards the respondent numbers 1, 2, and 3, 1, 2, 3, 4, and 5, the petitioner is directed to take steps by way of speed post. In addition to that, the petitioner is also directed to effect service by way of dusty upon the respondent numbers 1 to 5, routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner, while taking the dusty service, shall ensure that the service is meted upon the respondent numbers 1 to 5 on or before 19/12/2026-25. Full stop. In the writ petition dated, full stop, the present writ petition has been filed challenging the work order dated 14/10/2025. Full stop. The instant writ petition is connected with WPC number 6542/2025, wherein this court have stayed the work order. Full stop. Accordingly, the similar interim directions are hereby passed not to give effect to the work order dated 14/10/2025 issued in favor of the respondent number 4 till the next date.
Lordship, I apologize for that. I am appearing on his instructions, Lordship.
Yes, please, Lord. The present petitioner before your lordship are lessee of 2 cars, lordship settled by the Hasanikar Gaon Panchayat under Dhuguri Jilla Parishad. Lordship, during the lease period and in the lease period, lordship, the respondents issued the implement order, lordship, case.
What are you
Yes.
challenging, Mr. Sarkar?
Case 23, lordship. However, lordship, the respondent authority established a new park ghat and allotted the same to the private respondent without closing tender. Case 23.
Newly established Parghat for Amsar to LNT at Trivandrum with reference to you are allowed to manage the year. It is being given to some Totamiya. Who is he?
Who is,
Totamiya is being given
yes, lordship, without closing tender.
without closing for tender.
Lordship, this order initially passed for a period of 1 month. Subsequently, it was extended. Case 20. And later on, it was extended, lordship, case 30.
Now, there is already a step taken by the chief executive officer.
Yes, lordship.
Then,
Lordship, chief executive officer, lordship, there people after lordship, chief executive officers, lordship, thereafter, lordship, this extension order was passed, lordship.
up to so and so. This is without a tender.
Without tender, case 30, lordship. That development come after, lordship, the executive officer letter, lordship. Case 28,
Issue notice returnable on 19/1/2026.
May I please your lordship, two different parghats, this one, earlier.
Different?
Kindly see the page,
the present petitioner's lordship are settlement holder of 2 parkers, lordship.
parghat, and he,
The present petitioners are the lessee of 2 parkers, lordship.
the two different.
No, here we are concerned with the Ghat Amser to LNT Road Amser. That is the,
That is different.
concerned.
That is different. His lordship, the petitioner's parghat was, page number, kindly see annexure 3. This one is, Airang Jangla New Parghat. And awarded 3, Abdul Majid. This one, and Parghat is BSF camp checkpost to Airang Jangla New Ghat. This one is settled, but he challenged that this one is different. He is not.
Lordship, within the leased area of the petitioner's lordship, this new
Two
park
different
has been
park.
established and private respondent operating the same within the territorial jurisdiction of the petitioner's lordship. That's why we have agreed.
So not on the ground that without tender it has been done.
Three grounds we have filed lordship basically, without floating tender, another ground lordship. The Panchayat authority does not have an independent power lordship to establish new park, and third one is lordship, we are facing financial loss due to establishment of new park lordship. These three grounds basically we have challenged. On that ground lordship, we are praying for set aside the tender lordship, settlement order in favor of the private respondent.
Yeah, issue notice returnable on 19/1/2026. Ms.
Lordship, may I
Enbora
please
accepts
say
notice on
lordship?
behalf of respondent number 1, 2, 4, 5, 6, 7, 8. Mr. K. Gogoi accepts notice on behalf of the respondent number 3. Extra copies of the writ petition be furnished by tomorrow. As regards the respondent number 9 and 10, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, the respondent numbers 9 and 10 also the petitioner is further directed to take steps by way of dusty routed through the registry of the court on so and so. And the petitioner shall ensure that the service is meted out upon the respondent number 9 and 10 on or before 19/12/2025. The case of the petitioners herein is that both the petitioners are settlement holders of Parghats under the Gaspara Gaon Panchayat.
Actually, this is Hasanichar Gaon Panchayat, sir.
Huh?
Hasanichar Gaon Panchayat.
Yeah,
Hasanichar. This is
it's very difficult to read
Yes,
what is there, no?
lordship. Actually,
Both are Gaspara Gaon Panchayat.
no lordship, in top lordship, kindly see, office of the Hasanichar Gaon Panchayat, Bogulamad.
See the says who has signed it
Yes, lordship, this is the secretary of Hasanichar, seal is lordship Hasanichar Gaon Panchayat.
under we have been granted settlements by the Bhasanisar Gaon Panchayat
Yes, lordship.
in two different ghats. The Gaon Panchayat, the Birsing Gaon Panchayat had established a parghat from Aminachar to LNT Road at Aminachar under Birsing GP. It is the contention of the petitioner that the same was done unauthorizedly and contrary to the Assam Panchayat Act 1994 and the rules framed therein under. It is the further contention of the petitioner that not only the Birsing Gaon Panchayat had established the new Parghat, but also allowed the respondent number 10 to run the said Parghat for the period from 30/11/2025 to 36/2026. That too without any tender. On the ground of jurisdiction, as well as on the ground that the respondent number 10 have been permitted to run the said Parghat without following the without following the tender process, the petitioners have challenged the settlement order dated 27/11/2025 issued by the Secretary Bir Singh Gaon Panchayat. This court have heard the learned counsels appearing on behalf of the parties and given an anxious consideration as to whether the petitioner is entitled to any interim directions. The question as to whether the Bir Singh, whether the Bir Singh Gaon Panchayat has the authority to establish a new Parghat, and whether the same has been done by following the mandate can be only learned from instructions upon being produced by the respondent authorities. Further to that, as to whether any tender has been issued prior to settling with the respondent number 10 can also be asserted upon obtaining instructions, upon giving the respondents an opportunity to produce instructions. Considering the above, this court is not inclined to pass any interim directions as on date, today, but gives an opportunity to the respondents to apprise this court as to whether the Parghat which have been made by newly established by the Bir Singh Gaon Panchayat is in accordance with the provisions of the Assam Panchayat Act and the rules framed therein under. And as to whether further as to whether the Parghat in question have been settled with the respondent number 10 in accordance with section 105.
105. Section 105.
105 of the Panchayat Act 1994. It is observed that the interim order would be considered on the next date. The respondents shall bring on record their stand by filing their affidavits.
May I please, Your Lordship? Lordship, he is the settlement holder. Both petitioners are settlement holder of Hassanisar Gaon Panchayat under
Madam,
under BSF
Madam,
camp checkpost
I
and
have not passed any order.
but Lordship he has challenged another Gaon Panchayat.
Understood.
Lordship.
So therefore you you
Lordship.
take up that ground in your affidavit.
Lordship,
Don't you
Lordship.
think? If I passed an interim order, I would have recorded that. Didn't you?
Date may be fixed, Lordship.
I fixed it 19-1.
This is the pending order, my lord. Here, my lord, in fact, my lord, no notice has been given, my lord. Two tenders are issued. One is 9/12/22, which we have completed the supply, and 7/7/23 payment has been made. Another is on 20/11/23 for
Well, what banning notice? Where is the ban notice?
pending order, my lord,
Where is that?
page 91. They have issued the one,
2 years.
yes.
Then
My lord,
what is your ground?
Your Honor, no software notice has been given and no such a clause is there also in the contract, my lord. Anyway, no clause is there in the contract also.
No, clause
Anyway,
not
clause
necessary.
is there or not, my lord, I'm not on that. But no software notice has been given, no.
Hello, we have it after vacation. Issue a notice, no stay.
Central Government Council, sir, my lord.
Central Government Council have not appeared. That's another thing.
Yes.
But the fact remains that if I stay it without hearing them, without giving them an opportunity, because on the next day we can dispose it of. Because granting a stay out here has a lot of ramifications in a banning order. I'll take an opportunity. If I'm taking up the matter immediately on reopening, I'll finish it off. Don't worry. But I'll let them first be given an opportunity as to whether a notice has been issued or not. So cause proceedings were there. Because as of now, they may not have insurance.
Here, my lord, only my lord, one, exam has been issued, page 89, my lord.
Page?
Page 89, and where certificate has been given to me. Certificate has been given to me.
Whether your firm has complied with the minimum guaranteed VAF requirement as specified in the JAM cartet, provide detailed justification and calculation.
Yeah.
Submit your reply today, but within 1 hour, otherwise action will be taken for violating the procurement guidelines and the guidelines of GM Ministry. Then pursuant to that, this order is passed, na?
Well, I think it. And payment already made, certificate is there, my lord, it will also see at page 95. Is for a second, tender, my lord.
It's okay. You see, this order was passed on 27/10. Wait till January, we'll have it and issue notice. Issue notice returnable on 7/8/1/2026. Mr. K. Gogoi accepts notice on behalf of the respondent numbers 1. This, can you appear for NIT?
NIT also I cannot.
As regards the respondent number 2 and 3, extra copy of the writ petition be served upon him during the course of the day. As regards the respondent number 2 and 3, the petitioner is directed to take steps by way of speed post by tomorrow. In addition to that, the petitioner is also directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner shall also ensure that the service by way of dusty is effected upon the respondent number 2 and 3 on or before 19/12/2026. The petitioner herein is aggrieved by the order dated 27/10/2025, whereby the respondent number 3 had intimated the petitioner that the competent authority had decided to ban or suspend the petitioner's firm from participating in all tenders issued by the National Institute of Technology, Silchar, for a period of 2 years from the date of issue of the said notice. It is the contention of the petitioner that that the same was done without providing a reasonable opportunity, inasmuch as no show cause proceedings were initiated prior to such a decision is being taken. The learned senior counsel appearing on behalf of the petitioner submitted that, taking into account that the impugned communication dated 27/10/2025 has been issued without following the mandate of, without following the principles of natural justice, the impugned communication be stayed pending the next date. It is the question as to whether this court had given an anxious consideration to the said submission and is of the opinion that without giving an opportunity to the respondents to bring on record the stand as to whether any show cause the impugned communication dated 27/10/2025 was preceded by a show cause notice or not, it would not be proper on the part of this court to pass any interim directions, taking into account that such directions, if passed, would be amounting to the passing a final order in absence of the respondent number 2 and 3. Accordingly, this court shall consider as to whether any interim order is required to, interim directions are required to be passed or not on the next date. If the writ petition cannot be disposed of,
Order for implement of.
Huh?
Any date has been fixed?
Yes, I have fixed it. 8/1, no? 8/1/2026. You take your steps.
I have for implement,
Hmm.
DC Katsar.
Implement of
DC Katsar is respondent number 5, page number 5, madam.
respondent number
5.
Midul Kumar Yadav.
Yes, ma'am.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. K. Pukon appears on behalf of the respondent numbers.
5, your lordship. 5.
5?
Yes.
You are appearing.
Yes, middle.
You are yet to be impleted. How are you appearing?
Yes, your lord. Yes.
Appearing for?
Middle Yadav, your lordship. Now I am appearing for, I was appearing for Kriti Jalil. Jalil, she is no longer, your lordship.
Understood, but you can't appear today. You are appearing for respondent number 4.
Yes.
So, okay, appear for respondent number 4. So, this is an application filed for impleting the opposite party number 5. Opposite party number 4. This is an application filed for impleting the opposite party number 5 to the accompanying contempt application on the for the purpose that in order to on the ground that the opposite party number 4 have no longer the deputy district commissioner Kachar, and the opposite party number 5 is the present district commissioner of Kachar. So considering the above comment, it is therefore the opinion of this court that the opposite party number 5 be arrayed as the respondent number 5 to the accompanying contempt application. The petitioner is directed to file a fresh memo of parties in the accompanying contempt application, and the registry shall, on the basis of the said memo of parties and the present order, make necessary correction in the cause title and also update the same in the CIS. I stands closed. Econ newly conditioned. Issue notice upon the respondent number 5. Ms. K. Foucault submits that she has instructions to appear on behalf of the respondent number 5. Extra copy of the contempt application be provided to her after making necessary correction in the cause title. First, list this matter on 9/2/2026. In the meantime, the respondent number 5 is given the opportunity to file the affidavit.
Macho.
Oblige, your lordship.
For admission item 22.
So in this case, instead of going to file my affidavit yesterday also. So I need some time to file my reply also.
What?
That,
File my affidavit yesterday only.
he wants his security deposit, my lord. He wants his security deposit, my lord, to be returned, my lord. We have already sent him notice, my lord, because without executing work, my lord, he took the money of about 44 lakhs, my lord. So, lordship, last occasion I produced, I have.
You have filed a reply.
So, lordship, there's happened with yesterday lordship.
Huh?
I want to file reply lordship. Office happened with yesterday lordship, only yesterday.
In the form of.
Not only.
You have filed an
My lord,
affidavit.
Filed affidavit yesterday.
bringing the, my lord,
Bring the record.
inquiry report.
It has been submitted that the respondent number, that the state have filed an affidavit
Okay.
in pursuance to the order dated 10/11/2025. Mr. N.J. Gogoi, the learned counsel appearing on behalf of the petitioner, submits that petitioner would like to file a reply. List this matter again on 9/March/2026. In the meantime, the reply be filed.
23.
The pending amount is of the hill development scheme. when instructed me to if I affidavit in reply, my lord. So your lordship may decide on the basis of my affidavit in opposition filed by the customer.
So therefore, you have already got 21 lakhs 1,600.
Yes,
You want the 41 lakhs 49,600,
my lord,
which they are disputing.
my lord.
So therefore, the only recourse is to file a suit. Can this court decide? Yes, what is your stand? Oh, this is the matter, na?
Yes, my lord.
Where you have paid the money to him.
Yes, my lord. Yes. Yes.
Why are you opposing? What is this bill verification committee? Why they are opposing?
My lord, if you, no,
No, my lord, may I kindly come to the affidavit that has been filed on behalf of the respondent number 3. There, we have categorically stated, my lord, this is a centrally sponsored scheme, and under this particular scheme, my lord, monies have been paid to state or union territory in advance. Thereafter, my lord, state
No,
allotted.
therefore, you are not opposing his claim.
I am not opposing, my lord.
Therefore,
I am
I am
not
asking
opposing.
him.
My lord.
Yes, Mr. Das. Why you are opposing this? What is this bill verification committee's business?
yes, madam. Madam, if your lordship kindly peruse the affidavit of opposition filed by the government of India.
Forget about that. I'm not on that. You said that you oppose 41 lakhs for 49,600
Yes, madam.
is disputed. Why? You can't dispute just for the sake of it.
No, madam. Madam, since there is a dispute, so the directorate has formed.
What is the dispute?
Dispute is, madam, that this amount is not correct, and he has to submit a fresh bill on the correct amount, my lord.
What is the correct amount?
Correct amount, my lord.
Kindly say, my lord, page 63. Mail given by the state.
Where is the correct amount?
Correct amount, my lord.
There is two.
If your lordship comes to the paragraph 40, paragraph 8 of our
Huh?
affidavit.
Para?
Not para 8 of our affidavit, page 91. There is a mention that he has claimed an amount of rupees 70 lakhs. The para 8. So, madam, this amount will be.
So what are the objections? What are the objections?
Objections are there, my lord. So,
No,
madam,
no,
they
you
have
can't say that there are objections.
Yes, ma'am.
What is this
But
objection?
now, madam, the thing is.
One has to look into it.
Yes, we'll look it, my lord. We'll look to it, my lord.
File an affidavit. What are the objections?
Before that, madam, may I have?
We do one thing. We fix another matter on another date. You ask the petitioner to visit him and also tell your person should tell him what are the objections
Madam.
and let the petitioner settle it if it is possible.
Madam, before that, madam, regarding the funds.
No, I'm not. They have paid.
No, madam, there is no fund. Lordship, may kindly come to page 101, madam. Kindly come, madam. Lordship, may. No, explain. Let me explain, madam. What do you want?
No, he said that all payments have been made in advance.
This particular, wait, my lord, this particular scheme has been discontinued from April 2017. And the claim of the petitioner is of 2015. Now, my lord, may
When
kindly
did you
come.
stop?
Huh?
April
2017. 17, 2017.
The claim is 15.
His claim is on 15. My lord, may kindly come to my affidavit as page 70.
Page?
I would like to.
Page.
Page 70. This is the affidavit that has been filed by the respondent number 4. There, my lord, at page 70, my lord will find a chart.
Now, when you are paying in advance,
Yes, my lord, we
No,
are paying.
no, wait. When you are paying in advance, are you not asking for the utilization certificate?
Yes, my lord, that is
Have
right.
you got it?
My lord, we do not get utilization certificate.
Huh?
My lord, utilization certificate is to be. Page number 101, my lord. Utilization certificate.
No, no, I'm asking you.
My lord,
Mr.
this particular.
Dekar, no, no, Mr. Dekar, tell me one thing. If the central government pays certain money,
Yes, my lord.
you will ask for a utilization certificate.
Yes, my lord.
You paid for the month of, for the year 2015-16.
Yes,
This,
my lord.
this period is for the period 14-15.
Yes, my lord.
14-15.
1450.
14-15 or 15-16? Your bills is up to when?
1415.
14-15.
Maybe 1415, my lord.
Okay. So
we are-
you don't release 15-16
Yes, my lord.
or 16-17 without getting the utilization for 14-15.
Yes, my lord.
That's the manner in which the central government functions.
My lord, in this case, my lord, it is slightly different, my lord.
What?
We advance to the state government.
Huh?
We paid advance in every financial year to the state government. Thereafter, state government used to pay to the respective VTS, vocational training centers or AB,
No, understood.
assessing bodies. my lord.
Everything is understood.
Yes, my lord.
But once you pay, don't you ask for the utilization certificate?
Maybe, my lord.
100%.
My lord, the
Without
utilization-
that, you cannot.
But what I want to bring to your lordship notice is that till 25/8/2020, there was a fund lying with the state government amounting to rupees 4,37,19,962. Why the state government is not paying? That we are totally unaware of.
Mr. Counsel, I hope I've not been able to make you understand.
Yes, my lord.
Central government, whenever they pay,
My lord.
they will ask for the utilization certificate. If you don't give the utilization certificate, the central government will not release subsequent funds.
Deeply obliged.
The fact that the petitioner's claim is for the period from 2014-15,
Deeply.
and you have you have further released in the year 2015-16, which is apparent.
Yes, my lord.
Therefore, the meaning thereby that there has been certain utilization certificate given, otherwise you don't release it.
Yes, my lord. Yes, very right. My lordship is very
So
right.
the utilization certificate will be given of the petitioner's name.
My lord, that instruction I will have to
And if it is
obtain.
not given, then the question is, and this amount is duly covered out there from the utilization certificate, then obviously the question does not arise that you have paid to the petitioner of the state. And if there is a utilization certificate given
Yes, my lord.
of the petitioner, as regards this amount or certain amounts utilization certificate has not been given, for which you are asking, you will definitely keep on asking, because otherwise your audit will ask you.
Yes, deeply.
Then in that case, the state can be burdened.
Yes,
Because the state's specific stand is, look here, you have not given us this money.
Deeply obliged, my lord.
But your stand is that we have given that money.
My lord, that instruction.
So between your person, between both of you, the petitioner is suffering.
Yes, my
So you just find out
deeply.
in view of the stand.
I shall try to find out, my lord. I will take necessary instructions from the department.
This court have duly taken note of the stands which have been taken by the respondent number 2. Your respondent number? 2, as well as the respondent number 4.
My lord, 4 I am representing, my lord.
Wherein one respondent, the respondent number 4, categorically mentions that no funds from the respondent number 2 have been received. Whereas the respondent number 2 in the affidavit says, avers that due funds have been paid to the state, to the respondent number 4. List this matter again on 16th of March 2026. In the meantime, both the respondent number 2 and 4 shall take appropriate steps to arrive at a conclusion as to whether the whether any amount have been paid by the respondent number 4 to the respondent number 2 on account of the petitioner. And further to that, while making that verification, also make necessary enquiries as to whether the amount which have been paid by the respondent number 4 to the respondent number 2, there is any utilization certificate not furnished. The said be brought on record the respective stands of both the respondent number 2 and 4. On the basis of such verification is brought on record and by filing affidavits by 12th of March 2026.
Deeply obliged, my lord.
This matter relates to non-payment of the outstanding bills of supplier.
What is that?
I have filed my affidavit.
Please, what is your instruction?
I have filed the affidavit on 5th of December, my lord, whether it is on record. That's I said it, no. Paragraph 3, my lord, is. আপুনি ইমান প্লেন কৰিছে কিন্তু আমাৰ ইয়াতে নহয় এইটো হয় ইমানটো দিয়া হয় চাইছে নে আপুনি? আপোনাৰ petition নেকি? আপোনাৰ petition.
So how much is the petitioner entitled to?
My lord, as per paragraph 3, my lord, 2 bills are there, my lord. So one,
3 bills.
one is, my lord.
No, first is,
part-
kindly come to paragraph 1,
my lord.
3.1.
Yes,
That's some 3,000 something.
yes, it's left, and my lord,
That is okay. You have paid 2,25,000.
yes, my lord,
Now 3.2, 12 lakhs have not been paid.
my lord, now,
And then you have 87,000
yes,
not paid
my lord, 10 lakhs 87,000, my lord, remaining, my
for
lord.
an amount of 87 and so 45,000 is there.
2 payments.
The remaining balance was sanctioned and already paid to the petitioner. So therefore, the remaining proposal for remand are at the headquarters for sanction. So
Sanction.
only 10 lakhs 87,000.
10 lakhs 87,000, and my lord, as I have calculated, my lord, 3,594 in are, my lord.
And that must have been deducted for some
My lord,
taxation
some
purpose.
taxation purpose.
So this amount we give you 10 lakhs 87,000.
My lord,
এইটো paragraph 3 and 3.1 and 3.2 quote কৰি দিব পুলিচৰ case 10 lakhs 87,398 admitted accordingly হেতু এই direction গিটা দিব DGP 6 months.
obliged.
Bye.
My lord, FDSL has filed their counter to file my reply, my lord. Some more time required.
You have not filed.
No, I have not filed, sir.
Chalo. Interim order.
No, interim order.
It is seen that the petitioner was given the opportunity to file the reply by an order dated 10/11/2025. However, no reply has been filed and the counsel appearing on behalf of the petitioner seeks a further accommodation. List the matter only upon filing of the reply by the petitioner.
My lord, as for the court's order, I have filed a reply, my lord.
Oh, this one.
Yeah, my lord.
This is your reply
Yes, my lord.
to the affidavit filed by them.
Yes, my lord. Mainly, my lord, my point is on,
What do they say in the affidavit?
some wrong information was given, my lord. There are 4, my lord, they are affidavit, my lord. It's a wrong information, my lord.
What is the name of the petitioner?
Ditul Methi, my
Huh?
lord. Ditul Methi, my lord.
Vipul Medhi.
Yes, my lord.
The Jitul Medhi.
Yes, my lord.
Jitul Medhi. Where is it? How much did you quote?
My lord, his bid was for, my lord, serial number 1, 3, and 4. And out of this, my lord, he was the highest bidder in serial number 3, my lord.
Huh?
And his bid amount, his bid was for, my lord, serial number 1, 3, and 4, my lord.
Now tell me one thing, madam,
My-
interesting aspect. 6 and 8, na? Prosanto Deka and
And my.
respond number 8.
Yes, my.
Prosanto Deka or Das?
Yes, my lord.
Das lordship.
Das is-
Prosanto Das.
Yes, my.
You have made him Deka.
My lord.
Why?
Typographical mistake, my lord.
You have not corrected it.
No, my lord.
Then how can I pass an order against him? Tell me.
No, my lord, it was, my lord, detected only after filing of their, my lord, affidavit. It was not.
But how do I pass an order? And the other one is
One Gunojit Das lordship.
Gunojit Das. Where is he in the serial number?
My-
He quoted 6,11,000. And many people, and who are the first bidder? What is this first?
My lord, our 32 numbers of vehicles are there, my lord.
Ah.
And in this bid, my lord. the
So you got
petitioner-
one vehicle, AS 16F9805.
My lord, kindly see, my lord, it will be easier, my lord.
Lordship, if I may, in our affidavit, Lordship, the 2 vehicles in question, so we have attached the list in our affidavit, Lordship, at page 38. The 2 vehicles in question in this case, Your Lordship, page 38.
My lord, in these 2 vehicles, the petitioner was the second highest bidder, my lord.
Then
Then, my lord, there is a notification, my lord. A notification, my lord, let me see.
Lordship,
what
on
is that? What does the notification say?
May I submit on 3/11/2023, quotation inviting tender was, quotation inviting tender was called for, my lord, by the respondent number 3. And on 7/12/2003, petitioner placed his bids, my lord, for serial number 1, 3, and 4. And out of this, my lord, on 9/1/2024, the evaluation committee's report was published, my lord. And according to this, my lord, report, my lord, the petitioner was the highest bidder for the serial number 3. And he was the placed as second highest bidder in 1 and 4. Well, thereafter, my lord, on 18/1/2024, my lord, a notification was issued by the respondent number 3, whereby it was directed to deposit the earnest money within 3 days from the date of notification. So accordingly, the petitioner filed his earnest money for the vehicle number, for the serial number 3, my lord. And his vehicle was handed over to him on 24/1/2024. So when he inquired about the other 2 vehicles, so we came.
So 6 and 8 did not submit the within 3 days.
Earnest money.
But later on they accepted it
Lordship.
on the basis of the representation.
On the next date, Lordship, on the 18th, Lordship will kindly peruse page 35 of our affidavit, Lordship. On the subsequent, on the next day.
Afterthought, my lord. It is afterthought. On the very next day, my lord, they have modified the notification and extended the time period. When the petitioner visited the office on 24th and on 25th, nobody told him that the time period has been extended. And he also filed his representation on 25/1/2024. Nobody told him about this, my lord.
Now the vehicle has become bad now. What are you doing there? I think enough.
So they have, my lord, the respondent number 3 himself, my lord, he has violated his, my lord.
In any case, lordship, this affidavit has
And he-
been filed. on
Okay,
the
when should
records,
I,
lordship.
when should,
There is, my lord, there.
when do I dismiss your petition? Tell me. I'll dismiss it. I'm not going to allow your petition. When do I dismiss?
He has violated his own, my lord, notification, my lord.
Who?
When the respondent number 3, the secretary, my lord.
What did he violate?
But my lord, according, he issued a notification on 18/1/2024.
At the end of the day, what do you want? You want the
He
cards?
should be punished, my lord, because he has violated the, my lord, that his own notification.
Or that go to the criminal courts to be punished. I can't do anything. I am not there. I can't help you. Okay, when do you want to be dismissed? I gave you the satisfaction of getting some orders from them, nothing more than that. They filed the affidavit and all these things. You see, respondent number 6 is Prasanto Deka or Das. You have made Das or Deka, something like that. Wrong. And this obviously service has not been meted out. This is affair. Now they have given that. Now car has gone. We have better things to do. When do you want the dismissal?
My lord.
Next year?
My lord.
Next year or this year? Dismissal, when? I'm going to dismiss it. Okay, list this matter on. We'll have it after the Uruka Bihu. Then it's there. Okay? We'll dismiss it on then. On 21st of January 2026 at 2 p.m. for final disposal.
My lord, to follow up this process, my lord. If my lord, the secretary himself violates his own, my lord, notification, what remains more, my lord?
Madam, there are
Only,
obviously there are good reasons. One can very well go deep into that. At the end of the day, you are not going to get the benefit.
27 and 28.
of like that.
David, they have filed a lot.
What is the matter?
The highest has been lost.
Huh?
Highest is bill, my lord. We have admitted the amount, my lord, 2,22,97,620. And my lord, remaining 37,000, paragraph lordship will find.
7 lakhs.
You have filed affidavits
My lord,
in
On
both the
20
cases.
in both the cases, my lord.
In both the cases, do you admit some amount?
Yes, some amount, my lord.
Okay.
But if some amount they have sent for sanctioning authority and some amount is still under verification as per the certificate.
Huh?
Some amount, in respect of some amount, they are still under verification. Your Lordship.
Which one?
This item is 27.
Some amount.
Lordship.
Where?
Is 157 Your Lordship.
Page
187. Remaining amount.
187. এই আজি যে অৰ্ডাৰ এটা দিছো নহয় য'ত এটা এমাউণ্ট পেমেণ্ট হ'ব আছে এইটো দিয়া নাই এইটো দিব দিছো আৰু ইখিনি যোনটো ভেৰিফাই কৰিব দিছো যোনটো এডমিট কৰিছে টু বি পেইড উইদিন 6 months আৰু যোনটো এডমিট নাই কৰা ভেৰিফাই লাগে that it be paid within 6 months after verification. এইটো এটা অৰ্ডাৰ আজি সাইন কৰিছো না এই হেতুৰ নিচিনা Madam,
My lord.
whoever has drafted this affidavit
My lord, Yes, my lord, that calculation has not been done, my lord. that-
It's
that
okay,
don't-
no problem. Who has drafted it? You filed it, na?
I filed
You
it.
have the soft copy of this affidavit.
Oh, lordship,
You kindly give it to him.
better.
Because these details, na, it will become otherwise very difficult. Because these are details, one mistake, some number mistake will have a file. So this, if we can just incorporate this paragraph,
My lord.
5 and 5, paragraph 5 to
Lordship,
50, huh?
lordship, that
Paragraph 5.
lordship,
Yes, you just give him the affidavit, the soft copy, paragraph 5 to quote, huh?
my lord, I'll
You dispose of it, you make it. And what about the other one?
That two affidavit they have filed, it is.
my lord, last affidavit.
Only 75,890 they have distributed.
Second affidavit filed on 3rd of.
So here paragraph 3.
Two affidavit is there, Your Honor.
Paragraph 3, 9,88,000.
My lord, my lord, my lord.
8,000 in terms of the initial affidavit, there another affidavit is there. Your Honor.
Wait,
This was filed on 22/5 of 20.
this is filed on 3rd December.
December, this is the
There
latest.
there is an affidavit, Your Honor.
I am not going to go, there is only one affidavit.
This affidavit was filed, herein lordship, they have admitted the amount in respect of 10 lakhs which has been mentioned in this present affidavit.
Uh,
That was under scrutiny. And
Yeah.
after completion of scrutiny, they have filed this present affidavit indicating the rest amount of 10 lakhs which was under scrutiny.
No, here is only 9,88,000.
Mal admitted amount.
Lordship, this is the
And
affidavit.
No.
75
Are you going by paragraph 3 or not?
My
If you go by paragraph 3, well, otherwise you go to civil court.
Lordship,
No, go to civil court.
I did petition, I will have to file for it, sir.
No, of course, no. that is-
Now here they say that the remaining bill amount of rupees 10 lakhs. How much did you claim?
Lordship, kindly, in the original affidavit, Your Lordship, there was verification of 10,60,000 was about to verify. Other was admitted in the first affidavit.
Okay, so no, so therefore at paragraph number 4, they say that you have verified and found that 37 lakhs, 35,901 is payable.
Lordship.
And
Remain-
10 lakhs,
Remaining 10 lakhs.
63,983, 939 was to be verified.
My lord.
Now they verified and put it in paragraph number 3 of the subsequent affidavit that you are entitled to 9 lakhs. So this 9 lakhs plus this 37 lakhs is the payment total. Etut apuni paragraph number 4 to quote koribo of the affidavit filed by the respondent number 6 on 22/5/2025. And pursuant thereto, due verification was carried out in respect to the entitlement of the petitioner for the amount of rupees 10,63,939. And it was found that the petitioner's actual entitlement is rupees 9,88,049, which is evident from the fact evident from paragraph number 3 of the affidavit filed by the respondent number 7 on 3/7/3/12/2025. Paragraph number 3 of the said affidavit filed by the respondent number 7 is reproduced herein under. Etu puri, etu disposed. Etu 37 plus 9 lakhs plus puri is equals to Iman is the admitted amount. Payment so and so DGP within 6 months.
29.
How much?
Please, Your Lordship. Lordship, in this case, the department was directed to produce the records, my lord.
Lordship, I have the records.
What is this?
My lord, the work orders were cancelled without informing.
Work order cancelled.
Cancellation of
Then?
work orders without intimation to the petitioner. And
Oh,
he-
so then on that day, I asked for the perusal of the records pertaining to the
Yes, sir, the
cancellation. You have
records,
got it. Now, did you find out that whether notice was issued or not? Because
Because issued to them, Your Lordship. We have the records already. They are now, they're saying that their
they
address
have
was
not
changed.
received it. That
They
is
said
the-
their address has changed.
What?
They are saying in an affidavit that their address has changed, Your Lordship. In the affidavit reply, they
No,
said,
no, was the notice received?
yes, notice is there, Your Lordship.
Notice is there is a different thing. You may have it in the file.
Yes.
You may use it for whatever purpose you want, but the fact that whether the petitioner has received the notice is the question. My question is that because otherwise, how do you go for that cancellation order without a notice.
At 11:3, the notices should, but here it doesn't say whether received or not. But thing is that now the petitioner says they have not received the notice because their address has changed. They are not residing there, their office is not there. So now I like to place that if their office is not there, there was no intimation made to the authorities regarding their change in address.
It was during it. He is regularly visiting the office of the
No.
executive engineer.
And they have not said in their pleadings whether they have, where they have not made a statement.
Hello, we'll have it after vacation. Produce the records when.
I have
This is the matter again on 27th of January 2026 at 2 p.m. For final disposal. Mr. R.R. Gogoi shall produce the records on the next date.
Right. 31.
Matters pertain to non-payment of contractor delivership. Amendment post title has been filed on 3/11, but respondents' name not shown in the Colby's version. 6, 7, and 8.
Who is appearing for the respondents? Number 6, 7, and 8.
Central government, central government.
None appears on behalf of the central government as well as on behalf of the respondent number 8. On behalf of the accountant general audit when the matter is taken up. Who is paying for respondent number 6 and 7?
It's 7 central government, Brahmaputra board and Jal Shakti department.
6, 7. I'm for Union of India.
Why haven't you filed the affidavit? Why haven't you filed your affidavit? You don't want to file affidavit? Again's name is there. Her name is not shown in the cause list. Okay, it is seen that it has been submitted that in the cause list, the name of the respondent number, Ms. A. Gayan, who represents the respondent number 6 and 7, and Mr. A. Sharma, who represents the audit, the respondent number 8 have not been mentioned, have not been shown. So consequently, list this matter again on 2nd of February 2026. First off, the registry shall show the names of the respondent number, the councils representing the respondent number 6, 7, and 8 in the cause list. First off, a final opportunity is given to the respondent number 6, 7, and 8 to file the affidavit. Bring on record their stand by filing the affidavits on or before 31, 2026.
31.
My lord, I have instructions that the Mohal is running, my lord, it's operating.
I have no instruction, my lord. He is sick.
Extension of CI had permission to go.
No, his is okay. That is one thing which you have given an opinion that it should be allowed to
That, my
run.
lord, it's running.
So Mohal is running, but
Yes.
he wants some period, some renewal or something. What is that? That is the other thing. But renewal
he
is
has
not
to
permissible. no?
apply, my lord, their rules are there. Renewal he has already applied.
My lord, maybe you have taken up a vacation, my lord. I will take instruction. He is sick, my lord. Yesterday also, I did not.
The renewal, my lord, he has applied.
He has
That will be
applied.
considered if he fits the parameters. That's a different issue, my lord. But other than that, that other anxiety that it's not being run. On the last occasion, he said that he is not being allowed. It is being allowed, my lord.
That is another issue.
No, no. In fact, last time also you said
Yes, yes.
that has also rendered an opinion for permitting the petitioner to run the Mohal in question for the remaining settlement period, and he submits that there is all likelihood that the same shall be permitted within a few days.
Yes. It has been
It has
given.
been submitted by Mr. D. Gogoi, the learned standing counsel of the Forest Department. Forest, na?
Well,
This
yes,
is what?
Forest.
Forest Department, that the petitioners, that the Kakoi Sand Mahal, sand, gravel and earth. What is the Mahal name?
Kakoi,
Sand,
gravel and earth mining.
Art, MCA.
MCA,
Mining contract area.
contract
concession.
area.
Concession area, mining concession.
Contract area is presently in operation. Mr. J. Sharma submits that he would like to obtain instructions from his client as to whether the petitioner would like to further pursue the present proceedings or would approach the respondents as regards its prayer for renewal. List this matter on 13th of February 2026.
Good.
32.
Yes, Mr. Sen,
But in this case, the petitioner, my lord,
you have filed the affidavit.
Yeah.
my lord, they have filed affidavit, in opposition, my lord. But we need to, my lord, file our reply in this case,
Okay.
because,
Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply. List the matter only upon filing of the reply. No interim order. Is there any interim order? Oh, let him file.
it's a date, my lord, otherwise.
When you file, it will come. I said, now list the matter upon filing of the affidavit.
The sooner the better. The sooner he files, the better, lord.
You may file tomorrow, it may come before vacation. But if I file in and you, then you take a sign, time is gone, na? Yes, Mr. R. Sharma.
It is non-payment of bill, Lordship.
Here also.
What is it?
Lordship.
Yes.
The police.
67.
Huh?
And the 11th paragraph is paragraph 10.
Paragraph 10, Malad, page 70 is the Malad relevant portion. Malad.
So here you admit 1 crore 29.
Yes, sir.
Malad.
So I have verified this local.
Verify. So this is the direction. Okay.
Malad.
Paragraph 3, 10-1, 10-2, 10-3 query. Huh? 10, 10-1, 10-2, 10-3. Good query. Itu admitting amount of rupees 1 crore so and so. 1 crore 29, 11, 008. 6 months.
Nice.
Before.
Where we go? The application regarding my rejection of my prayer for grant of arm license. On the ground of there was no trade perception.
Oh, not recommended.
Yes.
What do they say by filing an affidavit?
Same thing, my lord, it has not been recommended by the authorities. No trade perception was found. my lord.
Reason not necessary. You wanted what?
We'll file our affidavit, arms license.
You want
Lord, we will
arms.
post it, my lord.
Huh?
No, biddings are complete, Lord, so we will post it for admission. Yeah.
Chala.
The contract payment.
Okay. List the matter on taking into account the pleadings are complete. Mr. P. Kotoki, the learned counsel appearing on behalf of the petitioner expresses urgency to list this matter on 4th of February 2026 at 2 p.m. for final disposal.
35 and 36.
Here, I order dated 28 August, my lord. My lord directed the respondents to file affidavit on or before 4th of December, my lord. Till date, no affidavit has been.
Who is to pay? MNREGA to, who is to pay money? Will the state will pay?
PNRD department.
PNRD. Chalo. PNRD is appearing who?
My lord,
Madam, why no affidavit filed?
Lordship, we are discussing with the department, so after vacation, we will file our affidavit.
Without fail.
Lordship.
Chalo. 5th by 1. First date. Because I have already given you 4 months. Do you
Lordship,
need
Lordship.
6 months for filing affidavit, then take an order after, pay after 6 months? Means coming to the High Court means 1 year. It is seen that no affidavit has been filed by the respondent authorities in spite of specific directions being given to file the affidavit on or before 4/12/2025. So considering the above, Ms. N. Bora, the learned counsel appearing on the standing counsel of the PNRD, submits that one additional opportunity may be granted for filing the affidavit. List this matter again on 4th of February 2026, a final opportunity is given to the respondents to bring on record their stand by filing the affidavits on or before 29th of January 2026. Failure to file the affidavit, this court would dispose of the incident with petition on the basis by applying the principles of the doctrine of non-traverse in addition to passing appropriate further non-traverse.
And
But they have not filed it.
Lordship instruction received. Lordship, I have received instruction.
Originally, some documents belonging to the son number 6 was filed wrongly. Now I am having the right document by an additional affidavit. But the important document backed up, settlement order and comparative statements are all. Backed up comparative statement and settlement order, these are all in the original decision, but other documents wrongly belonging to the son number 6 was filed by me. Now I am filing an additional affidavit with those documents filed. Belonging.
You want to file an additional affidavit?
My lord?
You want to file an additional affidavit? You are appearing for?
I am referring for BTC Lordship, BTC.
Huh?
BTC.
BTC.
Portland Territorial Council.
Who is appearing for the private respondent? 6. You have filed your affidavit. And the state have not filed the affidavit. BTC?
I have received instruction.
What is your stand? Why have you given it to the second highest bidder?
Lordship, please come to the comparative statement, Lordship. In the writ petition, Lordship, page number 35.
Yes.
Please, the respondent number 5 fulfilled all the criteria, Lordship. Mandatory requirement, NIT clause number 8, due to non-fulfillment of the mandatory requirements, Lordship.
What is the name of the petitioner?
Mandatory requirements not due to non-fulfillment of mandatory requirements such as income tax GST. This is mandatory requirement, Lordship. NIT clause number, please come to again page number 14, Lordship, annexure number 1.
Not required below 75%. That is the
NIT?
GST not required.
NIT, even Lordship, bank clearance certificate also not furnished during the time
Where is the NIT?
tender process, Lordship. NIT, Lordship, page number 14, Lordship.
What are the
Mandatory
requirement?
clause number 8,
Income
Lordship.
tax is required.
Required, Lordship, as per this
GST
terms and
clearance is
conditions.
mandatory in case of market area above the value of the
Bank
ceiling
clearance-
rate of
bank
75,000.
clearance,
GST clearance is only required after above 75. This is only 15,180. Why do you need that? These are in the tax clearance certificate from the concerned black development officer. Tax clearance is where block is given. What else do you require?
Explain to have valid.
Then income tax is not required, taking into account that he comes, he's exempted under 1026.
As per
Then-
the instruction, Lordship, maybe first.
Huh?
As per the instruction, Lordship.
Read instruction number 9.
I think that's on the page 44.
Number 9, read number 9.
9. On the recommendation of detailed
Allowed. Mr. Sharma would like to hear also.
On the recommendation of Didian Market Settlement Committee, BTC, headed by its chairman, and approval of the competent authority settlement of policy bi-weekly market under Dodoma Development Block was made in favor of the second highest bidder of bid value of rupees 17,181. So and so, only though the first highest
Though
bidder has fulfilled
The
all the criteria.
first highest bidder has fulfilled all the criteria of the NIT.
Although here in the comparative statement, Lordship,
And what is this instruction? This instruction is either wrong. What?
I have also noticed this.
You have also noticed, but you are not making the submission. That is your instruction.
Instruction is not clear, Lordship.
Well, here he says, na, we have given it to the second highest
In the
bidder,
comparative-
but you file an affidavit on this. Better.
Again, Lordship, I will obtain.
It is
right
seen that
settlement.
Mr. So-and-so appears on behalf of the BTC and submits that though he has received an instruction, but the instructions are contradictory, are self-contradictory. So taking into account the above, let's this matter again on 21st of January 2026. In the meantime, a final opportunity is granted to the BTC to bring on record their stand by filing the affidavit. Interim order passed earlier shall continue till the next date.
The Indians may be granted by law. India may be allowed to continue.
I'm said,
Next one is also same, my lord, but the
next one same.
same petitioner.
Lordship, I will obtain instruction, Lordship. Instruction.
Next one.
Next one,
Same.
Lordship.
List the matter on so-and-so. Affidavit be filed and the final opportunity to file the affidavit on so-and-so. Interim order passed earlier.
Yeah, India is not granted, may be granted.
Interim is not granted. Chalo. We'll have it on the
39.
Lordship.
Yes. What do you have to say? Concede.
No, my lord, we are awaiting instructions, my lord. There's one small aspect that needs to be clarified.
After 2 months also, you are not getting. So, no affidavit has been filed by the respondents in spite of due opportunity has been granted by the court. It therefore appears that the respondents are not in an urgency. There is no urgency in the instant the respondents have no urgency in an expeditious disposal of the instant petition. Accordingly, this court adjourns the matter and directs the listing of the matter only upon the affidavit in opposition is filed by the respondents. The interim order passed on 17/10/2025 stands extended until further orders.
Lordship, contextual admit amount lordship. Contextual admit amount lordship. Would is there a date fixed for instruction by the PNRD department lordship?
Lots of instructions waited in this case. Instructions waited.
Madam, this is the second round of litigation. Does it look nice?
Lots of actually as the terrorist.
People are losing faith
Ever-
with the PNRD, including me. I'm losing faith.
Actually, as the terrorist matter, as the terrorist matter.
What?
But as the terrorist matter, but he's.
Hello, none appears for the PNRD.
No, Lordship,
Then?
I'm appearing. So instructions waited.
You file your affidavit. This, I'm not going to give time before vacation.
Chip.
Please the matter on 19/12/2025. In the meantime, a final opportunity is given to the respondent PNRD to bring on record their stand by filing the affidavit.
Lordship. Upwards.
What is this? Site visit.
It has been issued finally, madam. It was somewhere misplaced, my lord, finally issued. That is the instruction at para 3. Or else it can be closed.
I have passed one order now when they've issued the site visit certificate later on. Or it was issued earlier, but there was no fault on your part. So therefore, to take, directing them to get my order এটা আছে, by which I have disposed of. One of your matters I have disposed of. You also forget this after getting so many site visits orders, huh? এইটো আমাৰ ডিসপোজাল কৰা আছে এনেকুৱা অৰ্ডাৰ এইটো থল এইটো এয়া দিব যে সাত বিজি এখনৰ ইনষ্ট্ৰাকশনটো এনেকে দি প্লে দি আমি কৰিছো সিট উইল পাস দ্যাট অর্ডার
Yeah, at least we can proceed.
হ্যাঁ
We can proceed.
and you can proceed and this is the direction it will be allowed in your thing instruction con x কৰি দিব হা
So in this case, we file our affidavit today, Lord. In this case, we file our affidavit that is on record.
today
Lord.
the reason
Lordship for the application.
what is
was-
your reason or it is not on record
It was recorded. I called, it was called for and it is placed.
not on record
Obvious means of.
okay we have it other side affidavit received
Yes, my lord.
it has been submitted that the affidavit in opposition has been filed on behalf of the respondent. However, the said affidavit is not on record. List this matter on 19th of December 2025. The registry shall bring on record the said affidavit.
To 57.
One matter, sir.
Commissioner has filed affidavit, madam, here.
Commissioners filed, but in fact, they actually indirectly, they're admitting that I am entitled to that machine.
But.
No, the problem is not that. The problem is they don't have the supply.
Supply, no. We can't.
You are
exceed-
entitled to, but they are not having supply. So you have to make out the grounds from that targeted order as well, targeted order that they are bound to give you that.
The Prime Minister, the entire case here lingers on because when we first applied, we had to come to court. They were given, then we file a contempt case. Then they comply. Then after this is going on, matters. They are not providing us the machine, nothing. Because the license was the consequence of a contempt case. There's a-
Understood, but the question is,
Mm.
for this court to pass them a direction for providing that epoch where they don't have, I think there is some guidelines issued by the state.
Sorry.
You find it out.
Is-
You will get it in one of my judgments where I passed as regards the 50 or more retailers. I passed a judgment where a question was challenged as because what the government did is they tagged all licenses having all consumers beneficiaries having 50 or more ration cards.
So 50.
That,
So in that, I dealt with these epoch machines. There it is a requirement. Have a look at that.
I'll try.
yes.
At least this matters again when?
January, after vacation. In the meantime, I'll get that.
6th of February,
My-
6th of February 2025.
Problem.
In the meantime, if the petitioner is at liberty to file replies on or before 2nd of February.
Problem.
Not admitted amount, it can be closed. Just we are praying for a reasonable time, at least 3 months to make the payment.
Itu record to itu likhi dibe, put it on record and mark with the letter X. Full stop. Ar ekhon quote koi dibo. Contents of is quoted, taking into account direction delivered to deposit to pay disburse the amount of so and so to the petitioner within 1 month.
3 months, man.
1,90,000. This is an old matter, very old. You have already issued everything. Within 1 month from the date the petitioners 45 days from the date the petitioner furnishes the certified copy of this order along with the bank details to the respondent number
Filed by the SSA.
to the
2 months.
respondent number 2.
2 and 3, man. It is a 2 and 3, they will coordinate and make that.
Full stop, respond, full stop. Upon submission of the said, the respondent number 2 and 3 shall do the needful so that the amount is disbursed to the petitioner within the time period above mentioned.
That's all.
Dispose.
The settlement of the market, my lord, second time litigation, my lord, first order, your lordship go to the, my lord, page 48, my lord.
Affidavit filed.
Affidavit is document.
Which department is this?
Municipal, my lord. Service is completed, my lord.
Anybody appearing for the respondents?
Only as per number 6, Lordship, who got it declared.
Anybody appearing for the state fishery department? Why no affidavits have been filed? Huh? What?
They are challenging the action of the minor respondent number 4, Chairman Tezpur Municipal Board member.
No, here is challenging this some amount of all quoted the same bid.
Same, 4
So,
bidders.
but you have given it to the respondent number 6.
But it is by the Tezpur Municipal Board, man. Municipal Board is the minor.
Service is completed already. But affidavit of-
This is done by the Tezpur Municipal Board.
Yes, madam.
No worry, you appear for respondent number 3.
Man,
File your affidavit on behalf of that because the chief executive officer is there. You are paying for 1, 2, and 3. You file your affidavit 1, 2, 3, and 5. Okay, chairman, you may not,
My
but for 3 you can.
My lord. My lord.
You've seen that the official respondents, more particularly the respondent numbers 1, 2, 3, and 5 have not filed their affidavit in the position. Full stop. Please also notice that this is the second round, na?
The second round.
Second round of litigation. Considering the above, list this matter again on 11th of February 2026. Full stop. A final opportunity is given to the respondent numbers 2, 1, 2, 3, and 5, for whom Ms. Yuda, the learned additional senior government advocate, appears to file the affidavit on or before 4th of February 2026. So on the next date, the respondents, more particularly the respondent number 3, is directed to produce the records pertaining to the settlement in question so that an attempt can be made to dispose of the writ petition.
Obla.
2 weeks time, ma'am.
Ah.
Yeah, I pray for 2 weeks time, madam. My lord, more portrays in the
Madam, last time you have
My lord,
taken time on the ground of wrong file.
wrong file came, it's correct, my lord.
Okay, you pay 10,000 cost to him.
My lord, I have sent, I have sent, my lord, only, I could send it on 9th, my lord, because I have to charge the copy, my lord. So it's a internal thing, so I don't want to, my lord, disclose this before the court, my lord.
Oh, he gave the copy 9.
My lord, he has shown me the receipt, my lord, that we have received, but we couldn't find out. Even then, my lord, I
Okay. Ms. Yudas, the learned counsel appearing on behalf of learned additional senior government advocate submits that only instructions were sought for on 9/12/2025.
my lord, scan copy I have.
First of taking into account the above, list this matter on, when did I fix the earlier matter? 6/4, na? 6/4/2026. In the meantime, the respondent authorities are directed to bring on record their stand as to whether the petitioner is entitled to the amount as claimed and when the said amount would be paid.
My lord.
In the meantime, with the pending disposal of the pending the next date, it shall not be a bar on the part of the respondent authorities to release the payment to which the petitioner is entitled to.
The electricity amount balance. I have received.
Oh, yes.
I have received the instruction. There are active consideration for a positive outcome, my lord. I have received it, but just needed some few days to come up with a proper.
Before vacation, now we need the that day I really felt bad yesterday dismissing one of the writ petitions of Mr. Sayawala. I need a smile from him before the end of the year. They give us
My
a
lord,
positive
may
outcome.
keep it in the first.
Huh?
Whenever my lord, my senior.
Before vacation, you do that. While claiming amount, you are doing it. I'm not asking you to adjust the amount, pay it or refund it, to adjust whatever he has deposited with the future bills. But as regards that, you can't put these 3 out there. You claim it. Why you're not filing a suit?
That's already,
We are
that is already
concerned
under
also
process.
the PDCL's thing, state of affairs. The matter is receiving due attention and the requisite instructions are in the process of, however, the same is likely to take a little more time to the process. You are requested to submit and pray the short date to be granted to us. Can we have it on 19th?
My lord, next Thursday is.
You are there only asking for short date.
My lord.
Okay. Mr. S.P. Sharma, the learned standing counsel appearing on behalf of the APDCL, submits that pursuant to the notice issued by this court, he has obtained instructions and the respondent authorities are duly looking into the matter and seeks a short date. In that regard, he has placed before this court an instruction dated 10/12/2025, which is kept on record and marked with the letter X, list this matter again on 19/12/2025. Orders की साइड यही मन मन रुकिए सब orders की साइड even order था so dota orders
Orders item 43 to 44.
yes why the matter has come
Lordship, we have filed our affidavit today, Lordship.
your file
Lordship.
when did you file
Lordship, sometime in the afternoon, Lordship.
service is complete oh because of the contempt it has come I suppose
Yes, Lordship. We have filed a affidavit in the writ petition, Lordship.
not in the contempt of case is huh? affidavit filed in contempt
No, Lordship, in the writ petition, Lordship.
why you are not filing it in the contempt
Lordship.
okay we ask this person to appear
No, Lordship.
no it
Can we
is
submit,
enough
Lordship, in the writ petition itself?
no you have taken this court very lightly
No,
no
Lordship.
we ask this person
No,
to appear.
Lordship, because in the writ petition, we have
This is
clarified
not
that the
I am
interim
very
order,
sorry.
Lordship, indeed has been validated, Lordship.
Huh?
The interim order has been validated. We have admitted that in the writ petition, Lordship. In the affidavit which we have filed in the writ petition, Lordship, we have mentioned that against which order this contempt has been filed. It is admittedly, Lordship, it has been validated, the interim order. We have admitted in the writ petition itself,
then
in the affidavit.
chalo list this matter for admission on reopening on 28/1/2026 interim order passed earlier shall continue till the next day repetition of divo first of next itu divo contempt a final opportunity is given to the petitioner respondent to bring on record the stand by filing affidavit failing which comma this court shall proceed assume that the respondent have nothing to say as regards the instant contempt applications list the matter on so and so okay did huh next date no more
Lordship.
matter over yes what is
Lordship,
this
with regard to this, Lordship, today I have received telephonic instruction, Lordship, that in the EC meeting, Lordship, there has been a decision to pay the dues of the petitioner.
well
Lordship.
10 lakh was supposed to be paid what happened
Yes, Lordship, thereafter, Lordship, in the review, an order was passed, Lordship. This is the, we preferred a review petition, Lordship. It was,
review dismissed
yes, Lordship, and it is specifically stated in the order, Lordship, the petitioner refused a payment of 10 lakhs.
No, Lordship. He has, they have not deposited the amount before the registry, Lordship.
Admittedly, Lordship, but we had
Why
taken,
they have the petitioner not received, Lord?
Lordship will
They
see.
did not submit the amount before the registry, Lordship, as directed by the review court.
forget about that we are not concerned
Lordship, in any
10
case,
lakhs when you are paying
Lordship, I will bring.
before vacation
Will
you
bring our stand.
you said that you were going to submit the 10 lakhs before the registry
Lordship,
pay him before vacation
Lordship,
let him end the day end the year with the 10 lakhs
Then
we'll consider the
perhaps
remaining
Lordship can
12
fix it
lakhs
before
later
vacation, Lordship, will bring our stand by way of an affidavit, Lordship.
what affidavit
Lordship, because today I have received telephonic instruction that the council has decided to clear all the contempt dues as expeditiously as possible. So,
what is this expeditiously
so Lordship, let me bring my stand on record,
okay
Lordship.
list the matter again on 18/12/2025 on which state by which state an attempt shall be made to deposit the amount of rupees 10 lakhs by the respondents before the registry of this court.
Lordship, if I may submit, Lordship, because previously we had difficulty while depositing the money to the registry, Lordship. That is,
Then that means you have made a wrong submission before the court.
no, Lordship.
That court.
No, Lordship, we made all attempts, Lordship, but the money was not debited, as Lordship can see in the order.
Okay, okay. It is seen that no payment has been made by the respondent authorities in spite of the review petition which was filed was dismissed. Full stop. It is also seen that there is no attempt also made to make any payment. Considering the above, comma, the respondent, considering the above, the Secretary, Finance, Boroland Territorial Council is directed to provide the head of account of the BTC. Full stop. Head of account for the BTC in respect to the head of account of the finance department of the BTC. Full stop. Mr. So-and-so, who appears, who is also the standing counsel of the respondent of the BTC, shall intimate the Secretary, Boroland Territorial Council about this order and for providing the details. List the matter on 18/12/2025. Full stop. We'll attach it. So before vacation, you should also not be happy. So yes.
This matter pleadings are complete.
Okay. What was the mistake I have completed?
Let's opt for the wrongful assistance, but 13.
There is no mistake. There is no error apparent, Your Lordship. It will amount to rehearing the entire matter.
But that is their contention. That's it. Basically, the issue was that whether the LOI is necessary or not. That's it. Their own operational guidelines says that the LOI is not required for obtaining subsidy. Notice was issued, 18/6/20.
Hello, we have it after vacation.
Maybe.
That day only I should have dismissed it when Mr. D.K. Mishra was there. What do you say?
Lordship wanted that the issue of promissory estoppel would be the second count, and Lordship was of the view, once your Lordship has issued a notice, Lordship said that what has fallen from my Lord, that once I issue the notice, that means I'm allowing the petition.
Huh?
That means I'm allowing the petition. That what has fallen from my Lordship. I have to correct.
I did it because Mr. Mishra took around almost one and a half hours for the notice. So then I felt really bad. So I issued notice. List the matter for final disposal on 10th of February 2026 at 2 p.m.
And review.
Obliged.
Everybody appears, huh? I'm glad. Affidavit is over. Respondent affidavit file?
Filed, Your Lordship.
Huh?
Yes.
Okay. Any opposition file? Reply you want to file? No. What is your stand?
They have already.
You have complied?
Direction is Tamsir Ali, Your Lordship, and we have already prepared the list of contractors, Your Lordship. We have annexed the list, and petitioner's name are in serial number 55 and 59, page number 26 and 27, Your Lordship.
Now, how much amount is left?
Lordship,
1,26,345. Isn't it?
yes, sir, that is the amount of one petitioner, petitioner number 2, Your Lordship, and petitioner number 1 is amount left is 18 lakhs 87,736.
In value of 21 lakhs 12,000, 2 crores, na?
Yes, Your Lordship.
Out
Some
of which
has been
rupees
paid.
so and so 22 lakhs was paid.
Yes,
Leaving balance 1 crore so and so. Further, the bill amount of so and so was paid and leaving balance so and so. Now, in compliance to the rule, I have already prepared the chronological list of contractors. Okay. So you are there.
yes, yes.
So nothing remains.
Yes.
Full stop. This is an application filed alleging willful and deliberate violation to the order passed by the court dated. Order is also not there.
Order dated 14.
Where is the order?
Page number 12.
I will not put, page 13 is not there. Order dated 14/12/2023 in WPC number 6054/2022. So this court have duly taken note of the affidavit so filed by the respondent number 1, and more particularly the contents of paragraph number 6 and 7 and annexure 1 and 2 to the said affidavit. From a perusal of the said affidavit, it therefore appears that the respondents have taken due steps for compliance and have also acted in compliance with the order passed by this court. Considering the above, this court therefore drops the instant contempt applications proceedings. Full stop. Full stop. The dropping of the instant contempt application, however, shall not prejudice their claim, which is put in the chronological list as mentioned in which is enclosed as annexure 2 to the affidavit of the respondent number 1.
Lordship, liberty may be given to approach this honorable court. Liberty may be given to approach this honorable.
I said na, without prejudice.
Much of this.
Where is this?
And this is,
Anything complied?
um,
Complied or not complied?
a positive proposal has been submitted before the finance department, before the finance department, Lordship. Approach to release plan finance.
So revenue has got the money. So you have put it to the finance.
Department, Lordship.
Now finance have not cleared it.
Not cleared. Just yesterday it is sent, Lordship.
It has been submitted. Mr. S. Toto, the learned standing counsel of the Revenue Department have placed before this court an instruction dated 10/12/2025, wherein it is mentioned that the necessary funds for the purpose, for necessary sanction, the Finance Department have been sought for by a communication dated 9/12/2025. The said communication is kept on record and marked with the letter Y. Mrs. Udas, the learned additional senior government advocate, further submits that the district commissioner and chairman district disaster management authority is yet to receive the money from the revenue and disaster management department. The said instruction is kept on record and marked with the letter Z. Taking into account the above, list this matter again on 28/1/2026 at the motion stage. Full stop. For an update. I think by the next date, if you don't do it, will compel to issue. Mr. Gogoi, any idea?
Lordship, just see the instruction here, the problem has arisen because when the work was done, there was only one division, the Dhubri. Now they've been bifurcated since some administrative hindrance was there. Now there was a meeting called by the chief engineer. So they are sorting it out. So the verification process, they are undertaking it, Your Lordship, now.
Mr. R.R. Gogoi, the standing counsel of the PHA department submits that some steps have been taken for the verification and it will be completed soon. List this matter again on 30/1/2026 for an update at the motion stage.
Very well. I'm highly obliged.
May I please, Your Lordship. Lordship, I have appeared for respondent number.
You're appearing for?
Respondent number 1 to 3, Your Lordship.
ONGC?
ONGC, Your Lordship. No, ONGC, I am for the respondent number 1 to 3.
Who is appearing
Not
for
for four.
ONGC? 4. Anybody appearing for 4? You are appearing for respondent number 1, 2, and 3, na?
Yes, yes, my lord.
Okay. ONGC,
On the last occasion, your lordship's order dated 22/9/25, Dosti sir.
Dusty service routed
Yes,
to the registry of
and
the
they
court.
were directed to file affidavit of service of.
You are for the petitioner or the respondent?
I am for the respondent.
So therefore,
Yes.
direction was given 1,
Yes.
2, and 3. Why ONGC they could not serve?
ONGC কি নম্বৰ হৈছে?
Sorry, no.
হেৰিটো service complete হৈছে?
There are so many councils who appear for ONGC. So list the matter, the service as regards respondent number 1, 2, and 3 is duly complete. Good stuff. As regards the
Sorry.
respondent number 4, comma, it appears that the service is not complete. Accordingly, the petitioner is directed to take fresh steps upon the respondent number 4 by way of Dusty,
D.
routed through the registry of this court. In addition to that, the petitioner is also directed to take steps by way of speed post. List this matter again on 9/2/2026.
Much of.
Mr. So-and-so appears for the respondent number 1, 2, and 3. Yes, Mr. Dasgupta.
In this case, your lordship, justice service is complete. Today is fixed for interim order.
They is not for interim order. Contractors shall not engage employer. Why the matter has come up like this? Notice has been issued away as per the no steps, no affidavit regarding Dusty upon respondent has been. You have not affected service upon respondent number 1 and 2.
Yes, sir.
Dusty,
For
That
one,
is-
for 1 and 2, I am appearing.
You are
Your
appearing?
Worship. I filed my wakalat number today. Your
okay,
Worship.
okay.
I am awaiting my.
1 and
parents'
2 is who?
comments.
Oil,
E-
ONGC.
ONGC, your Worship.
Why you are not appearing in the other matter?
Lordship,
That matter?
I have no knowledge regarding that.
No,
matter,
there
Lordship.
also you
This is
means
just-
they are having a difficult time. Okay, anyways,
This is not complete.
you are appearing for 1, 2, and 2, 1 and
1
2.
and 2, your Lordship.
1 and 2, and the union is 3, all represented. So taking into account that all the parties are duly represented, comma, the matter for admission on 18th of December 2025.
Lordship, I'm.
18th of December.
Oh, you are not there, na?
Lordship,
Okay, have it after vacation. List the matter for vacation on 21st of December, January 2026
21st of January.
for
Lordship.
admission.
I'm awaiting my pairwise comments, your Lordship, as soon as I receive.
You
them.
file your affidavit, whatever may be.
Yes, Lordship. Deeply obliged. Lordship.
What else about it? Oh, this one, somebody has filed a reply, na?
Yes,
Uh,
they filed an
no,
additional.
you have, no, what was, Ms. Chaudhary, what, Mr. PK Goswami, what did he submit?
That we had filed the rejoinder, Lordship, and they had filed the reply.
So you want to fix it for admission?
Also,
next
they
week.
have filed an additional affidavit, bringing a new document on record. We'll
You
fix
want to
some
file a
issue.
reply?
We'll file a
That
reply.
is what your submission
Yes,
was,
yes,
no,
yes.
Mr. Endeka? Okay. This matter, it has been submitted that an additional affidavit has been filed by the petitioner. And the respondent, NRL, na,
Yes,
would like
Number
to
2.
file a reply, rejoinder. Okay. Is there interim order?
no interim.
There is no.
Urgency? Urgency is there, na?
Others is there.
When do we have it after vacation? When?
Next week preferably.
Next week, not possible. It's filled up. You see, this, everything is filled up. Very bad things.
Immediately on reopening.
The reopening, will let us have it on 6th.
6.
6th is Tuesday. List the matter on 6/1/2026 at 2 p.m. on which date an attempt shall be made to dispose of the writ petition.
All right.
PK Goswami appear কৰা বুলি দিব দেই, PK টা আহিছে। PK Gulshan.
Stay affidavit, Lordship,
Huh?
on 26/11.
File the stay affidavit.
Yes, Lordship.
Okay. Service. Okay, taking into account the affidavit filed by the respondents, by additional affidavit, the affidavit of service filed by the petitioner, comma, list this matter for admission on 31/2026. Full stop. Interim order passed earlier shall continue till the next date. Ah, yeah, matter, last matter, good.
My lord, in this case, we tried to serve justice. The agency could not be found.
Lordship, I'm appealing for the response number 2.
Huh?
I'm appealing for that. Today we have filed local number.
Respond number 2.
Yes, Lordship. My lord, copy will be
Yes,
sent.
yes.
You see, only issue out here is as regards the back wages.
Back wages.
Others I have already turned down. So only is back wages as to whether you are entitled to
Hello.
full back wages or not. Argue that. You want to go for mediation, both of you?
Lordship, we fix on Friday, my senior will.
Both of you?
My lord,
I'll take instruction
I'll
on
have to
Friday.
take that instruction. I'll have to take that instruction from now on.
I have
No,
to
if
take-
you want, you can go. I can send you. We'll have it after 3 months. In the month
Lordship,
of March.
Matter,
On Friday, Lordship,
Now,
we have.
that is one, because of back wages. But this is a case of reinstatement, because he has been reinstated. What is the year? Whether, I didn't state the reinstatement. So therefore, has he been reinstated or not?
on that instruction, I do not have.
Okay, so there is a violation. So ask them to take action against, have you filed that application for putting them behind bars for non-compliance? You've not filed. Have you looked into my order?
Yes.
I said the reinstatement is not stayed. Have you
Yes,
been
yes.
reinstated or not?
Yes, yes. My lord, that instruction I have to take, Lordship. On telephone,
Okay,
instruction I have prepared, Lordship.
chalo.
So on Friday, Lordship, if go to the medicine, on
No,
Friday,
no.
we'll take instruction.
Okay. Taking into account that the service is newly complete, comma, list this matter for admission on 10th of February 2026. Full stop. On which date an attempt shall be made to dispose of the writ petition. Taking into account that the records are also already available. Full stop. Interim order passed earlier
Yes, my lord. It is till today.
shall continue till the next date.
Lordship, copy may be sent.
What?
Repetition copy.
We will serve, you just.